in the top right corner of your call. After you do this, to pin the timer, hover over a participant image that is not your own and click the three-dot icon, which is labeled More Options. From the pop-up menu, click Lock a participant to this location. Another pop-up will appear with the WebEx calls participant list, from which you will search and select the name of the timer screen. Let me know if you need me to run through those steps one more time. Or you can give me a thumbs up if you're good.
Sorry, pinning the, how do I pin the timer?
Okay, so depending on in what view you're in, just hover over another person's video and you should see it in the top right of their little screen. There will be a button that has like a three-dot icon, and it should say More Options when you hover over it. So when you click that, the next option should be to lock a participant to this location. And when you click that, there will be another menu that pops up with a search bar. And you can just search up timer in that search bar and click that, and it'll lock it to your screen.
Okay.
Did that work for you?
No, I've never been used to this. I can't click on more options. As soon as I move the mouse, more options disappears.
No, you don't have to click. You don't actually have to click more options. Just click the icon that you're hovering over that makes that pop up.
So is it supposed to say 5, which is what I just did?
Say 5.
Well, I went into the 3 dots and then there was the search function. Then I clicked on timer to fix the timer, and then the timer is on the screen and it says 5.
Yeah, it should say 5. It should say 5 minutes.
So should I get rid of it now, or should I leave it?
No, you just leave it there, and when the time comes, that'll be your timer.
Audio check, how's recording?
Okay, I'm receiving word from my colleagues that there might be a 5-minute delay in our start time. Um, Also, we might be expecting a recess in between for a vote, so just wanted to keep you updated. Thanks. Miss Lauder, if you can hear me, we have our CAO staff calling you right now to help out with your tech issue. So if you would please pick up for them.
All right, I said that's no problem. Thank you.
Dean, can we check to see that your audio is working?
Hi, this is Madeline. Can you hear me?
Yes, thank you.
Thank you.
And Mr. Jones, can we check to see that your audio is working? Mr. Jones?
Am I coming through okay? Am I coming through okay, guys?
And Mr. Owens, yes, we can hear you. Thank you.
We'll begin in just a couple of minutes. They're just resolving a technical issue, and then we'll get started.
Ms. Fishbach, can we check to see that your audio is working? Ms. Fishbach? Hi, Mr. Raskin. Can we check to see that your audio is working?
How does this sound to you guys? Sorry.
Sounds great.
Good.
Thank you. And Ms. Fishbach, can we check to see that your audio is working?
Is it working?
Yes, thank you.
Thank you.
And Ms. Jayapal, can we check to see that your video and audio are working?
Hi, good afternoon.
Good afternoon. Thank you.
Thank you.
General Wise, if you would please turn on your video for us. I want to just be sure it's up.
Pleasure to see you. Mr.
Great
Chairman.
to see you again, General. Should we ask Commissioner Slaughter to put our video on?
Hi, Ms. Scanlon. Can we check to see that your audio is working?
Absolutely. How's that sound?
Sounds great. Thank you.
Okay, thank you.
Hi, Miss Slaughter. Can we check your audio?
Sorry, were you asking for my audio? I was just on the phone with your tech support.
Yes, we can hear you. Thank you.
Okay, great. I'm having trouble seeing screens, but I can hear and you can see me, so I can just fly a little blind.
Hi, Miss Slaughter. Can we check your audio again?
Yes, how's my audio now?
Sounds great. Thank you.
Okay, great, thanks.
We will be beginning shortly. Thank you.
The subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. Good afternoon and welcome to today's hearing, the third in a series to develop legislation to promote competition online and to modernize the antitrust laws. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also like to remind all members and our witnesses that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings. I expect all members on both sides of the aisle to wear a mask for the duration of today's hearing. I now recognize myself for an opening statement. In 1950, Congress enacted the Selleck-Kefauver Anti-Merger Act, one of the last major amendments to the antitrust laws. This landmark statute expanded the Clayton Act's prohibition on illegal mergers to include stock acquisitions and non-horizontal transactions, reflecting the sense of Congress that unchecked monopoly power poses a threat to our economy as well as our democracy. Congress enacted the Anti-Merger Act in response to the extensive record created by the temporary National Economic Committee and the Federal Trade Commission on the dangers of severe economic concentration and recommendations to rein in dominant companies that had captured key sectors of the U.S. economy. As the FTC warned in 1948, and I quote, "If nothing is done to check the growth and concentration, either the giant corporations will ultimately take over the country or the government will be impelled to step in and impose some forms of direct regulation in the public interest," end quote. Following its enactment, the Supreme Court broadly construed the Anti-Merger Act in a series of decisions that reasserted the primacy of competition and the law over the rise and abuse of monopoly power, decisions which included Brown Shoe and Philadelphia National Bank. Indeed, as the court observed in 1962, this law clearly reflected, and I quote, "the danger to the American economy in unchecked corporate expansions through mergers, and that acquisitions with even a probable anti-competitive effect are illegal." But in spite of clear legislative intent, courts have systematically weakened the antitrust laws, limiting the analysis of competitive harm to focus primarily on price and output rather than protecting the competitive process. As Judge Diane Wood will testify today, the doctrine developed by the Supreme Court over the last 40 years has doomed many cases to failure, leading to under-enforcement. The antitrust agencies have also contributed to this problem by adopting a narrow view of their authorities, particularly in emerging areas of the law or in the face of litigation risk. Bill Baer, the former head of the Justice Department's Antitrust Division, testified before the subcommittee last Congress that the simple, quote, "fear of getting it wrong has warped antitrust," end quote, adding that the attitude that, quote, "uncertainty should result in inaction has also caused courts to require a level of proof that is often unattainable." As a result of these trends, market power has risen dramatically on an economy-wide basis, resulting in numerous industries that are dominated by just one or two companies. As my colleague and friend, Senator Amy Klobuchar, said last week in a seminal hearing before the Senate Antitrust Committee, quote, "America's market power problem cuts across our entire economy. We see it in everything from cat food to caskets," end quote. Numerous studies show high levels of market power and concentration across the U.S. economy, causing nearly everyone to question whether our competition laws and enforcement approaches are adequate to protect consumers from anti-competitive conduct and mergers, as Acting Chairwoman Rebecca Kelly Slaughter will testify today. Moreover, during our investigation last Congress, the subcommittee documented how today's monopolies have exploited these structural weaknesses in the law and lax enforcement to expand their dominance by buying or burying their competitive threats. For example, ahead of Facebook's acquisition of WhatsApp, top executives at the company plainly described its strategy as a land grab to shore up Facebook's position. In 2012, Mark Zuckerberg went as far as saying that the company could, quote, always just buy any competitive startups, end quote. In the years since, Facebook has certainly done so without receiving more than a single second request from enforcers. Google has similarly entrenched its dominance in the navigation app market, of which it controls an estimated 80%, and has been referred to by investors as a utility. It protected its market power through a series of acquisitions that eliminated any meaningful competitive threat. Prior to its acquisition by Google, the CEO of Waves, Noam Barden, said that the company was, quote, the only reasonable competition, end quote, to Google Maps, excuse me. Since then, he has commented that Waves could have probably grown faster and much more efficiently had we stayed independent, renewing concerns that this acquisition killed a competitive threat to Google's own mapping services while reinforcing its power in other markets. Our investigation also showed that once dominant, these firms engaged in a similar playbook of anti-competitive conduct to protect and expand their power. For example, according to its internal documents, Google recognized as early as 2005 that specialized search engines could pose a threat to Google's long-term dominance, noting that these search verticals could hurt Google badly. In response, Google deployed a series of tactics to advantage its own services and appropriate the content of other companies online. One entrepreneur, Brian Warner, told us that his website was thriving until Google stole his content, which led to a drop in traffic to his website by 80%, forcing him to lay off half of his staff. Simply put, this conduct is destroying opportunity and entrepreneurship while undermining the open, decentralized nature of the internet that made it a bastion for innovation. As Mr. Warner told us, quote, if someone came to me with an idea for a website or web service today, I would tell them to run as far away from the web as possible, end quote. We heard similar stories from other executives at small and medium-sized business companies who have been forced to slash jobs and cut research and development budgets primarily because of anti-competitive conduct by the dominant technology firms. Across the board, we are seeing less innovation, fewer jobs, and less choice while a handful of companies are growing larger and larger. As a result, the internet has become highly concentrated, less open, and more hostile to innovation and entrepreneurship. Although the Federal Trade Commission and the Justice Department recently filed lawsuits against Facebook and Google, challenging some of these practices as violations of the antitrust laws, this conduct has gone unchecked for far too long. This abysmal record was underscored by recent reporting by Leah Nyland of Politico on the FTC's investigation of Google's dominance in search nearly a decade ago. Hundreds of pages of internal memoranda by the Commission's economists and lawyers obtained by Politico demonstrate that despite significant evidence, the FTC was unwilling to challenge Google's monopoly power. As the documents made clear, Google sought to own the U.S. market through exclusive contracts with carriers and device manufacturers, which made Google the default choice for search on the vast majority of smartphones. Google's own employees acknowledged that these humongous payments, which totaled billions of dollars, were used to block rivals from the market. As Jeremy Stoppelman, the CEO of Yelp, has said, these documents, quote, show how Google methodically destroyed the web, end quote. And despite recommendations by the Bureau of Competition to file an antitrust lawsuit, the FTC voted unanimously to close the investigation. Over and over again, these examples provide case studies of why we need a massive overhaul of our antitrust laws and significant updates to our competition system. Today's hearing is an opportunity to take additional steps in that process by identifying reforms to develop and clarify the antitrust laws to confront America's monopoly problem. I thank our extraordinary panel of witnesses for their testimony, and I look forward to hearing today's hearing very much. And with that, it is now my pleasure to recognize the gentleman from Colorado, the distinguished ranking member of the subcommittee, for purposes of making an opening statement.
Thank you, Mr. Chair, and thank you for holding this hearing. I have been reflecting on last year's investigation and the ideas we heard during the hearings. In particular, I was thinking about the various proposals we heard at the hearing last October, where several areas for potential action were outlined, including increasing rigorous enforcement, reforming burdens of proof for big tech mergers involving a monopoly platform, instituting rebuttable presumptions, and codifying the consumer welfare standard. There are several areas where I believe Republicans and Democrats are ready to work together. But before I begin, I want to address the disinformation campaign the monopoly companies have launched around town. They are whispering to anyone who will listen that the proposals under consideration are going to apply to the entire economy. That's not true. I want to be clear for the record that the proposals I am supporting are limited solely to big tech monopoly platforms. We need to fully understand and appreciate the unintended consequences of our proposals. I am very concerned that any action we take should not impede our efforts to build a robust economy after the crushing blow we received from the pandemic. We must address predatory conduct of the big tech monopolies without jeopardizing other sectors of our economy. One area where there is agreement between Republicans and Democrats is that we need more robust enforcement of the antitrust laws. We need personnel at these agencies who are willing to bring the difficult cases. Just this week, Politico published a piece outlining the Obama-Biden Federal Trade Commission's reluctance to bring an antitrust case against Google for its anti-competitive behavior in the online search advertising, and mobile phone software markets. Among the revelations in the documents released by Politico was an email where a top Google executive bragged to the CEO that the company could own the U.S. market with its exclusive contracts with major smartphone manufacturers and telecommunications companies. Google also acknowledged to the FTC that it made humongous payments as part of those contracts solely to keep rivals like Microsoft and Yahoo from getting prime access to mobile phones. Their tactics obviously worked. Google is now the default search engine on 86% of U.S. smartphones to go along with their 94% dominance in the desktop search market. These contracts also form a major part of the antitrust suit that the Trump Justice Department and 11 states filed against Google. As we consider giving the FTC and DOJ more funds, I want to assure the agencies that any increase in funds will come with increased oversight and an expectation by taxpayers that the agencies bring the hard cases. We aren't making more taxpayer money available so this type of dilatory behavior by government bureaucrats can continue. I have been pleased to see the state attorney generals pick up the enforcement ball, and I've heard proposals that would assist them that I think would warrant further investigation, Mr. Chair. I very much appreciate the leadership and hard work of Attorney General Phil Weiser from my home state of Colorado. Mr. Chair, I would recommend a provision that would give the state attorneys general the same deference regarding venue selection that the United States enjoys in big tech monopoly cases. This fix would have major implications quickly. For example, Google has filed a motion to change venue, trying to move Texas's ad case to the Northern District of California, and therefore the Ninth Circuit, where they have favorable case law on appeal. This fix acknowledges our federalist system of government because it rightly recognizes the sovereignty of the states, and pragmatically, it would eliminate gamesmanship and forum shopping in these cases by the big tech monopolies. Another area where I believe Republicans and Democrats could work together is on reforming the evidentiary burden of proof in merger cases. The burden of proof has become essentially insurmountable and is basically a grant of near total immunity to big tech companies. And this is a big problem for consumers and market competition because these tech titans' buying spree has continued unabated for essentially the past 20 years. Estimates vary, but the number of deals involving digital platforms stands at approximately 750 over the past 2 decades. Facebook acquired its competitors Instagram and WhatsApp. Google bought its Google Maps competitor Waze. These deals were cleared by the antitrust agencies with a casual glance. And the buying spree continues. We now see Google trying to acquire Fitbit, which will result in a predictable duopoly in the wearables market. Apple and their iWatch, and Google with Fitbit. Other wearables will be stripped of their market share, and consumers will be left disrobed. Exposing this predatory behavior will ensure that risks don't go naked. And if consumers choose not to wear a wrist device, my conservative friends and I can protect a consumer's right to bear arms. There seems to be a certain arrogance to the way these companies operate. Congress has investigated them, the state attorney generals have filed multiple lawsuits, and they have been sued by the Department of Justice and the Federal Trade Commission, and yet they continue to act with complete impunity. Apple, Google, Facebook, and Amazon have reached monopoly status, and their behavior won't change until Congress acts, the enforcement agencies do their job, and the courts move quickly to rein in their predatory conduct. Third, I think another area we may need to look at is implementing a rebuttable presumption to deny mergers at certain dominance levels. In just a few years, we have seen the tech center in Silicon Valley transform from a nimble, innovation-driven force that was the pride of the American capitalist system to an acquisition-driven behemoth. Investment in R&D has evaporated along with self-generated innovation at these companies. The big tech monopoly platforms are now just whales inhaling the startup plankton. Lastly, I believe we can work together to codify the consumer welfare standard and remind the agencies and the courts that price is not the only factor that should be considered when looking at whether a merger will have a negative effect on competition. This change would reflect the reality that in big tech markets, competition is not driven by price or output, but rather by potential innovation and forward-looking competition reviews. Mr. Chair, I thank you again for your collegiality and your commitment to bipartisanship, and I look forward to working with you on these proposals. I yield back.
I thank the gentleman for yielding back. It is now my pleasure to introduce today's witnesses. We may take them a little out of order depending on the technical difficulties, but our first witness is Rebecca Slaughter, the acting chair of the Federal Trade Commission. She was appointed to the FTC in 2018 and is one of the nation's leading experts on competition, privacy, and consumer protection issues. While at the agency, she has been a staunch advocate for increased FTC resources and a vocal proponent for American consumers and workers. Before joining the FTC, Acting Chair Slaughter served as chief counsel to Senator Charles Schumer as an associate at Sidley Austin LLP. Acting Chairwoman Slaughter received her bachelor's degree from Yale University and her JD from Yale Law School. Our second witness is Diana P. Wood, Circuit Judge of the United States Court of Appeals for the Seventh Circuit. Prior to being appointed a circuit judge in 1995, Judge Wood served as Deputy Assistant Attorney General for the Department of Justice Antitrust Division. From 2013 to 2020, Judge Wood was Chief Judge of the Seventh Circuit. She is also a Fellow of the American Academy of Arts and Sciences and serves as Chair of the Council of the American Law Institute. Judge Wood received both her bachelor's degree and JD from the University of Texas at Austin. I'd now like to recognize my distinguished colleague, the gentleman from Colorado, Mr. Neguse, to introduce our third witness.
Thank you, Mr. Chairman, for your courtesy, and thank you for the opportunity to welcome our third witness, Phil Weiser, the Attorney General of Colorado, who has committed his life to public service. Previously, Attorney General Weiser served as a professor of law and a dean of the University of Colorado Law School, where he founded the Silicon Flatiron Center for Law, Technology, and Entrepreneurship. In the Obama administration, he was appointed to serve as the Deputy Assistant Attorney General in the U.S. Department of Justice, as well as a Senior Advisor for Technology and Innovation at the White House's National Economic Council. Earlier in his career, he also co-chaired the Colorado Innovation Council and served in President Bill Clinton's Department of Justice. He clerked after law school in Denver for Judge David Abell on the 10th Circuit Court of Appeals and held 2 clerkships at the United States Supreme Court for Justices Byron White and the late Ruth Bader Ginsburg. Attorney General Weiser, I want to thank you for joining us and for the tremendous work that you do every day on behalf of Coloradans. And I know myself and Ranking Member Buck look forward to your testimony.
Thank you, the gentleman in your box, and welcome, General Weiser. It's good to have you here. Our fourth witness, Mike Walker, has served as the Chief Economic Advisor for the United Kingdom's Competition and Market Authority since 2013. Prior to joining the CMA, he was Vice President of the European Competition Policy Team at CRA International in London, a team he established in 2000. He has also served as the Director of Competition Policy at London Economics, a Senior Regulatory Economist with British Telecom, and a Senior Associate at Lexicon Ltd. Dr. Walker is a co-author of The Economics of EU Competition Law, a professor at the College of Europe at Bruges, and a visiting fellow at King's College London. Dr. Walker received his bachelor's, master's, and PhD from the University of Oxford. Our fifth witness, Noah Phillips, is a commissioner at the Federal Trade Commission. Prior to his 2018 nomination and unanimous confirmation to the FTC, he served as chief counsel to Senator John Cornyn on the Senate Judiciary Committee from 2011 to 2018. In this role, he advised the Senate on issues involving antitrust, constitutional law, consumer privacy, and intellectual property. Commissioner Phillips is also an experienced litigator, having worked at both Cravath, Swaine, and Moore, as well as Steptoe and Johnson before his tenure with Senator Cornyn. Commissioner Phillips received his AB from Dartmouth College and his JD from Stanford Law School. Today's final witness, Doug Peterson, is 32nd Attorney General of Nebraska. He was elected in 2014 and has worked to defend the Constitution and laws of the state of Nebraska. Before being elected Attorney General, Mr. Peterson spent more than 20 years in private practice, advising and advocating for both individuals and businesses. From 1988 to 1990, he served as Assistant Attorney General to the Nebraska Attorney General's office, representing the state in employment law and tort litigation matters. Attorney General Peterson received his bachelor's degree from the University of Nebraska and his JD from Pepperdine University School of Law. We welcome all of our distinguished witnesses, and we thank you for your participation in today's hearing. I will begin now by swearing in our witnesses. I ask our witnesses testifying in person to rise, and I ask our witnesses testifying remotely to turn on their audio and make sure that we can see your face and your raised right hand while I administer the oath of office. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God?
I do.
Let the record show that the witness has answered in the affirmative. Thank you, and you may be seated. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there's a timing light in WebEx. When the light switches from green to yellow, you have 1 minute to conclude, and when the light turns red, it signals that your 5 minutes has expired. I now recognize Acting Chairwoman Slaughter for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ranking Member Buck and members of the subcommittee for the invitation to appear before you today. It is an honor. Promoting competition and protecting consumers is the FTC's mission, but current market conditions across the economy have caused nearly everyone to question whether our competition laws and enforcement approaches are adequate to protect consumers from anti-competitive conduct and mergers. Aggressive enforcement using the FTC's existing authority can and should be complemented by this committee's work to sharpen antitrust laws and to impose broader market-wide restrictions that address pervasive anti-competitive conduct and conditions. I believe the FTC must push antitrust law forward through bold agency action. Specifically, that means prioritizing deterrence and using the full range of the FTC's authorities to stop unfair methods of competition. The Commission has spent far too many of our enforcement dollars and limited staff hours to challenge mergers that are plainly illegal and should never have gotten out of the boardroom. It is clear we have a deterrence problem. To address this, we must develop a higher tolerance for litigation risk, advocating for the most effective remedies, including structural separations, and refusing to accept settlements that don't fully correct harm. At the same time, we must lay the groundwork for success for new theories and more aggressive enforcement. One way we are doing just that is with our announcement this week of a working group with international and domestic partners to build a new approach to pharmaceutical merger enforcement. We also need to make sure our merger guidelines, horizontal and vertical, chart an enforcement path that fully addresses competitive harms and is appropriately skeptical of claimed benefits. In addition to making our enforcement actions more effective, we need to dust off some important tools that have languished too long in our toolbox. We should activate our unfair methods of competition rulemaking authority to prohibit anti-competitive conduct that is difficult to litigate on a case-by-case basis. And we should consider bringing standalone Section 5 claims in our competition cases more frequently. We can work hard to be strategic and aggressive with our toolbox, but we do face acute and urgent challenges in carrying out our mission, and that is where the work of Congress comes into play. First, resources. While Congress has been very generous recently in helping our resourcing catch up to demand, we are not there yet. Just one new data point. In the first 5 months of this fiscal year, we processed 60% more HSR filings than we had on average over the past 5 years. In February of this year alone, we had more than twice as many filings as we did the year before. Even before this recent wave, filings had about doubled in the last 10 years, while our FTE count stayed flat. Another pressing problem for the Commission is the ongoing threat from the courts to our authority under Section 13B of the FTC Act. A series of bad decisions limit our ability to enjoin illegal conduct and seek monetary redress. In its motion to dismiss the Commission's antitrust complaint, Facebook cited these decisions and argued that Section 13B bars the suit. Together, all 5 commissioners wrote to Congress and asked that you swiftly restore the long-standing interpretation of Section 13B. I hope you will consider that request. On top of addressing those FTC-specific challenges, I also support efforts by this committee to reform the antitrust laws more broadly. Even our most effective enforcement efforts are no substitute for legislative changes that clean up bad case law, impose clear presumptions, and reduce untenable burdens on enforcers. These changes would minimize the need to engage in tortured and expensive efforts to both measure and balance harm and efficiencies, particularly in cases where the facts support a clear theory of harm. Changes to the enforcement framework can work in tandem with the broader restrictions on dominant platforms Congress is considering. I firmly believe that effective enforcement is a complement, not an alternative to thoughtful regulation. Our antitrust laws protect the democratic ideal of fair participation in a free society. I strongly support legislation that will facilitate protecting not only consumers, but all market participants, workers, entrepreneurs, and small businesses, especially those in marginalized communities, from monopolistic practices and exclusionary conduct. I look forward to working with this committee and others in Congress to consider the best balance of an enforcement and regulatory framework to promote competition, and I welcome your questions.
Thank you, Acting Chair Slaughter. Judge Wood, you are now recognized for 5 minutes.
Thank you very much, Mr. Chairman, Ranking Member Buck, members of the subcommittee. It's a real privilege to be here today to testify on such an important topic. I would like to make 3 key points for the subcommittee's consideration. First, I think it's important for us to recognize that the antitrust laws have always been concerned not just about a narrow concept of so-called consumer welfare, just in the sense of low prices, but also with concentrated economic power that chokes off vibrant competition and innovation. Second, it's not only possible, but essential that exclusionary practices once again be pursued seriously by all parties able to enforce the law: U.S. government enforcers, state attorneys general, private parties, because these practices have fallen by the wayside in recent years in terms of enforcement priority. Finally, and third, it may be time to consider legislative changes in the remedies area of the statutes, because we don't want to see antitrust practices go unredressed because either the standards are too onerous or the available remedies are too ineffective. I should stress as I discuss this that I am here expressing only my personal views on these subjects, nothing more. This is obviously hardly the first time Congress has considered legislative changes to the laws. And this is a time where perhaps clarification of the intent of Congress is really called for. Congress does this from time to time. Congress did this with the Americans with Disabilities Act when the courts seemed to be going in a direction that was not where Congress had thought it should go. So our antitrust laws, as I said, having always been about the problem of monopoly, need reinforcement that these kinds of monopolistic practices are part of what we're talking about. Senator Sherman himself singled them out when he first introduced the bill those many years ago. The original Supreme Court, the people who were contemporaneous with this, also recognized that this was about fair competition practices. That's why the FTC Act in 1914 spoke of unfair methods of competition. And so the question for today's Congress is whether we need to sharpen the law. People have spoken of presumptions, perhaps lists, and understand the breadth of its concern. I want to also discuss another thing, which is to say, some people are afraid that if we focus on exclusionary practices, we are not going to be able to tell the difference between good old-fashioned hard competition, which we like, and an anti-competitive exclusionary practice on the other side. I don't think that's a real risk. I think we can see when a firm has dominance, perhaps 40%, 50%, maybe the committee should consider a threshold. And when it starts to go, as we've heard, swoop up all of its rivals, it exploits government barriers, it grants exclusive rights, thereby freezing other people out of markets. Competition is being damaged, and we have the tools to examine that sort of thing. I'm not talking about the old-fashioned per se rule, which may have been too clumsy, but the rule of reason itself could be sharpened and made a more effective tool. So I would say the under-enforcement of the law has come from a couple of directions. And largely, I think, a sense that it's very difficult to proceed when the law in the courts has become so unfavorable. So again, there's room for Congress. And finally, in my last minute, I would like to just focus on remedies. For Section 2, all we have is injunctions, including divestiture, very important, and we have damages. Damages are difficult to prove, but it's certainly a good private tool. But perhaps we need to think more ambitiously. Maybe we want to add to the menu something like civil fines, or make very clear, as the chairman was talking about, that disgorgement of profits is acceptable. No one has to use these all of the time, but they are complements in many other countries, as we may hear, and it's a tool that perhaps the Congress should seriously consider giving also to the American governmental enforcers. I will leave you with one thought. The antitrust laws are for the protection of competition, not competitors, but we need competitors before we have competition. Thank you very much.
Thank you so much, Judge Wood. I now recognize Attorney General Weiser for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Buck, Congressman Joe Neguse for the kind introduction, and members of the subcommittee. I appreciate the opportunity to visit with you today. I have shared my filed comments, and today I want to get to the heart of the question that, Mr. Chairman, you focused on. A level of market power, a lack of concentration that calls on enforcers to take actions to restore competition and raises a question for policymakers. How did we get to this point, and what do we do about this? The short answer is that in some markets, we are seeing entrenched incumbents. We've talked about the area of tech platforms, where permissive merger policy, exclusionary conduct, and other actions have lessened competition. Now, I want to be clear, there are markets that function in a healthy manner with competition. Think, for example, the number of video streaming services that consumers can choose from. But in other sectors, in addition to big tech, airlines and pharmaceuticals, for example, we have too little competition and consumers are worse off. Let me start with airlines, for example. After a series of mergers, 4 airlines now control almost 70% of domestic air travel. And moreover, this industry witnessed a successful effort by American Airlines in the 1990s to stomp out rivals through predatory pricing and a mistaken court decision that allowed this anti-competitive harm to happen. So for consumers, this has been a blow to our pocketbooks. When fuel prices went down, consumers didn't benefit. The airlines made record profits, and as the New York Times put it, consumers just got peanuts. This decreased competition is not only bad at the pocketbook, but it means consumers are treated worse off. And during the pandemic, the #1 complaint we've gotten here, the Colorado Department of Law, it's about airlines, particularly Frontier Airlines, not following federal consumer protection requirements. That's why I led a bipartisan of attorneys general, 40 of us, including General Peterson and I, calling for state AG enforcement of federal airline consumer protection laws. We have to take a look that we have had too much concentration, and we have to ask questions, how did we get here? These retrospective studies are important, and we need more of them. What we also need to ask is, why have courts shown a reluctance to enforce the antitrust laws? And as Mr. Chairman noted, why has enforcers been afraid of bringing cases? The short answer, the Chicago School of Antitrust. Judge Wood is not necessarily a member of that school, although University of Chicago law faculty for a long time. This was a series of critiques of the antitrust laws, started out on sound economic concerns, but overshot the mark, as the late Bob Potofsky put it, and now have focused on the mantra that all we have to worry about is over-enforcement and not to worry about unenforcement. This mindset is wrong. It explains some of the mistaken court decisions, including the one that I mentioned. So where do we go from here? I would recommend 4 steps. First, we need enforcers to bring cases, to do their homework, know their industry, and not be afraid, to bring forth empirical evidence, rigorous economic analysis of competitive harm happening in the marketplace. That's what the U.S. Department of Justice did a generation ago when I was working with Joel Klein, and that unanimous Microsoft case that resulted from that leadership set an important precedent about exclusionary contracts, degraded access to a platform, and efforts to keep artificial barriers to entry high, thereby excluding rivals. In the antitrust cases that our department and other states, including Nebraska, have brought against Google and Facebook, we're alleging harm similar to that of Microsoft. In the case of Google, we explain in our complaint that Google protected monopolies in search and search advertising using exclusionary contracts and inhibiting rivals' ability to acquire customers. Like Microsoft in the 1990s, Google sees threats to its dominance from adjacent sectors and is not competing on the merits, but undermining the ability of rivals to compete. We must restore competition to the marketplace and lower barriers to entry. In the Facebook case, it was buy or bury the rivals. And the wrath of Mark Zuckerberg was well known, and that was talked about, and it was abused, where upstart rivals were either purchased or were buried. That's the opposite of what the antitrust laws are about, which is competition on the merits. We also need, as I mentioned, more retrospectives to understand where markets are not working, where we can learn from past mistakes. I appreciate the calls for funding and resources for the FTC and the antitrust division of DOJ do just that. Third, as we think about competition policy more broadly, it's not only about antitrust enforcement. Back to the airline industry, airports make leasing decisions based on landing gates. We need to make sure those decisions are made with an eye to facilitating competition. The same goes with respect to our patent laws and how we enable competition in pharma. And finally, yes, we need legislative action to address this wrong turn called for by the Chicago School. This Congress can make an effort and show leadership in antitrust enforcement, competition policy, and consumer protection. I thank you for your attention to these issues, and I welcome your questions.
Thank you very much, Mr. Attorney General. And now recognize Dr. Walker for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Buck, and other members of the subcommittee for this opportunity to speak. I've been asked to speak about what I think we in Europe have learned about the large digital platforms and how, if at all, they should be regulated. I think the starting point for thinking about competition policy with respect to digital platforms is to note that they undoubtedly provide great products and services that consumers and firms love, but to also note that this is not a get-out-of-jail-free card that should allow them to exploit their substantial market power to detriment to consumers, firms, and the economy. So, what do I think we have learned in Europe? Well, I think we've learned that the existing competition policy approach has failed with respect to the large platforms. I think we've learned that unilateral conduct cases on their own are not enough to restrict the digital platform's ability to exercise market power. They take too long, they don't remove the platform's entrenched market power, and there's no evidence that that entrenched market power is going to self-correct in the near future. I think we've learned that existing competition law is not able to deal with the adverse impact of platform development strategies, particularly with respect to undermining the ability of innovative entrants to be successful. And I think we've learned that competition policy should not act independently of privacy regulation. The European experience is that incumbent platforms have used privacy regulation as a protective shield against competitive threats. So my view is that the entrenched market power of these platforms requires regulation to restrict both their ability to exploit their current market power and their ability to enhance it by creating barriers to new entry. The key long-term objective of this regulatory regime should be to open up these markets to new competitors. It is competition, not monopoly, that drives innovation, and it is innovation that enhances consumer welfare. And I think in Europe, we've learned that merger control policy should be part of this regulatory regime. It has a key role to play in stopping existing incumbent platforms from further entrenching their market power. And we are all aware of past failures in this area. So what have we decided to do? In the UK, we are setting up a new regulator, the Digital Markets Unit. This will regulate firms with strategic market status. So these are firms with entrenched market power that has adverse effects across a range of markets. And firms that are found to have strategic market status will be subject to 3 types of interventions. First, a bespoke code of conduct that limits the ability of the firm to exploit its existing market power, and that code of conduct will be based on 3 broad principles: fair trading, open choices, and trust and transparency. Second, we'll have interventions, will be pro-competitive interventions to encourage new entry and innovation to challenge the SMS firms. Such interventions are likely to include remedies around personal data mobility, interoperability, and data access. Third, they will face enhanced merger scrutiny to ensure they cannot protect or enhance their market power via acquisitions. So the merger standard is proposed to be reduced to a reasonable prospect of harm, a lower standard than the current balance of probabilities standard. I think this is a super important part of the proposed regime. The best way to deal with market power is not to allow it to exist in the first place. And it should be noted that this is one area where the UK approach differs from the EU approach. The EU proposals don't include merger control change, and I think that's a significant omission. It's really important to note that this is not traditional rate of return or price regulation that is being proposed. The aim of this regulation is not to bake in existing outcomes, but to facilitate innovation and hence facilitate good competitive outcomes. I cannot stress enough that encouraging innovation is key to successful competitive outcomes. I should also note the code of conduct for each SMS firm will be bespoke to that firm. I mean, that seems right to me. The business models of the firms differ, and hence the source of market power differs across the firms. Google and Facebook are advertising funded, Amazon's transaction funded, Apple relies on devices and iOS App Store. Okay, two final comments. One, I often hear the argument that the future of these markets is very uncertain. The danger of regulatory mistakes is high, and therefore regulators should leave them alone. I think this argument is profoundly wrong. There are very substantial risks to inaction, such as markets tipping or incumbents driving innovative competitors out of the market. Inaction is not a neutral choice. It is an active choice, and in my view, the wrong choice. Finally, digital platforms are global players. In my view, this means that regulatory consistency between the US, Europe, and other jurisdictions is highly desirable, both to protect consumers and to create greater consistency for the platforms. Thank you for your attention.
Thank you, Dr. Walker. I now recognize Commissioner Phillips for 5 minutes.
Thank you, Mr. Chairman. Chairman Cicilline, Ranking Member Buck, members of the subcommittee, thank you for the opportunity to appear before you today. I am pleased to be before you with my friend and colleague, the acting chairwoman of the Federal Trade Commission, and the other esteemed panelists to discuss antitrust reform. Today, the agencies are engaged in vigorous enforcement in industries from tech to pharmaceuticals to consumer products. In fiscal year 2020, the FTC brought a record-setting 27 merger enforcement actions, the highest number in decades. Over the last 3 years, we have also brought 7 monopolization cases. We appreciate the funding that Congress has appropriated, which will help us to continue to enforce the law. Today's discussion concerns whether the law suffices. What Congress does will have far-reaching consequences throughout our economy. That will require careful consideration, and I encourage this subcommittee to continue to engage thoughtfully. The antitrust laws protect competition. Competition benefits society and consumers by spurring innovation, improving quality, and lowering prices. Companies, even industries, rise and fall, but the competitive process ensures that American consumers benefit. That is why antitrust focuses on whether a merger or other business conduct harms consumers. We care about prices, and no one should work to make Americans pay more for food or healthcare. But competition also means output, quality, and innovation. Businesses compete to hire workers and buy inputs too, and antitrust cares about all of these things. Antitrust is a powerful tool, but the laws are not designed to address every problem that large companies create. Even perfect competition cannot solve every problem. Some reformers seem to promise antitrust can solve everything, from the political power of large corporations to privacy, to labor rights, to racial inequality. Does competition help address social problems? Without a doubt. When companies compete to lower prices, for example, people with fewer means have access to more product. That is good for distributional equity. But antitrust is not and should not be a regulatory catch-all. This subcommittee has done its homework to understand some of the major technology platforms today. But many reform proposals are not limited to 4 technology companies. The antitrust laws apply to almost every industry, and many proposals that I have seen go broader than big tech. The antitrust laws are written broadly. Their breadth gives plaintiffs and courts the flexibility to deal with many issues, including in the tech sector. For example, the FTC recently has sued to block mergers, break up companies, protect platform competition, encourage new drugs to market, and stop contracts protecting monopolies. The important work we do is not just in tech, but hospitals, energy, consumer products, and pharmaceuticals. As you consider reform, animated in particular by a handful of the largest technology firms, I urge you to consider the impact on all businesses. The history of antitrust legislation includes unintended consequences. Some laws took money out of the pockets of American consumers or failed to check corporate power. The Robinson-Patman Act sought to protect small retail businesses from larger, more efficient chain stores. The unfortunate result was that American consumers paid more money for groceries and household products that they use every day. The 1950 Seller-Kefauver amendments to the Clayton Act, which the chairman mentioned, which are good and which we use today, were followed by a 2-decade merger wave. And the result was not the diminishment of powerful corporations, but rather the rise of gargantuan, unwieldy conglomerate corporations. It took America a long time to get out of that mess. Our nation is emerging from a crisis with tens of millions out of work and shuttered businesses. We want to encourage companies, big and small, to enter and meet consumer need. Mergers and acquisitions are one way that they do that. For example, the FTC recently permitted a large medical diagnostics company to buy a small innovator developing a rapid PCR test for COVID-19 and the flu. According to the companies, the combination of the innovator's technology and the acquirer's scale would enable the combined company to bring better tests to more people. That is a good thing as we race to put this pandemic behind us. Markets work better when companies are allowed to give consumers what they want. Government intervention is sometimes necessary, but it can also get in the way. The FTC advocates against state laws that prevent new hospitals or impose unnecessary occupational licensing requirements. Burdensome environmental and NIMBY permitting slowed the plans of both Presidents Obama and President Trump to improve American infrastructure. Competitive M&A is no different. We can and do stop the bad ones, but over-regulating will also stop good ones. The ability to sell a company...
Commissioner, I hate to interrupt your time as well, so if you could wrap up.
2 more sentences?
Sure.
Thank you, Mr. Chairman. The ability to sell a company encourages people to innovate and start them, and venture capitalists to fund them in tech, biotech, and consumer products. On the flip side, sand in the gears prevents the market from working. As you think about reform, please think about those facts. Thank you for inviting me today. I look forward to your questions.
Thank you, Commissioner. I now recognize Attorney General Peterson for 5 minutes.
Thank you, Mr. Chairman, members of the subcommittee, for the invitation to be with you today. I appreciate the opportunity to share with you my perspective and how to address monopoly power and revive competition in the modern economy. At the outset, I want to express my appreciation to the subcommittee for its impressive and extensive investigation into a potential anti-competitive conduct occurring with the big tech marketplace. Frankly, after 16 months of bipartisan investigation, you've reviewed over 1.3 million internal documents. You've considered 38 submissions by antitrust experts, interviewed over 240 market participants, and testimony at 7 hearings, including CEOs for the 4 major tech companies. So I seriously doubt that I can bring any new information to the investigation except to provide you one state attorney general's perspective on how we can bring better competition into the markets. I think it's helpful to look at a historical perspective. I think it's productive to step back and reflect where we've been with antitrust enforcement, not just in the US, but globally. For several years now, the foreign competition authorities have been very active in investigating and prosecuting big tech. They're to be applauded for their important efforts. The EU also passed the GDPR. However, I think they have rightfully asked, where is the US enforcement? And the answer is, in my perspective, is we are on our way. In the last 2 years, both the House and the Senate have initiated studies regarding antitrust enforcement during the digital age. Both the U.S. Department of Justice and the FTC have investigated and have filed antitrust actions against Google and Facebook. From my perspective, the most significant addition in the last 2 years is that 49 states, the District of Columbia, territories of Puerto Rico and Guam, have participated in both a multi-state investigation and have subsequently joined as parties to one or more of the 3 antitrust lawsuits that have been filed against Google and Facebook. There's never been a time in the US history where this number of states have exercised their dual authority to enforce the Sherman Act. The closest example would be the Microsoft case in the late 90s, where 20 states joined the Department of Justice. There's obviously among the attorney generals to see this type of number, a renewed commitment to our duty to enforce the Sherman Antitrust Act. And I think that is a significant sea change when you look at the number that have been involved in these 2 cases. The degree of collaboration between the state antitrust leadership and those at DOJ and the FTC has been outstanding over the last 2 years. Antitrust enforcement actions are resource-intensive endeavors and require armies of specialized attorneys, combined with both technical and economic experts, to be successful. As a result, enforcers are most effective when cooperating and coordinating our efforts. Cooperative enforcement was highly effective in the past cases such as Microsoft and the Apple eBooks, in which state and federal enforcers came together successfully to take on some of the world's largest technology companies. Today, we are synchronizing our efforts with federal agencies. State enforcers have become true partners with our federal counterparts by bringing separate yet coordinated enforcement actions, thus allowing us to bring more expansive and aggressive cases where appropriate. I recognize the House recently increased funding for federal agency enforcement and would encourage this subcommittee to seriously consider additional proposals to increase resources allocated to antitrust enforcement community to ensure that agencies have the resources necessary to successfully pursue our anti-competitive investigations. The Sherman Act has been the primary tool for antitrust officers to protect competitive markets for more than 130 years. And I want to talk just briefly about some of the discussion with regards to the changes that are being called for. Over the last century, it has offered an adaptable framework for a wide range of fact patterns. Antitrust cases provide each case a very factually unique setting, whether it's defining markets or the behaviors, or whether it's a highly regulated industry. I think the Microsoft case provides the best model for analyzing our current cases with regards to Facebook and Google. In Microsoft, the DC Court of Appeals endorsed the idea that antitrust harm extends beyond simple price increases or output reductions. Instead, the Sherman Act protects against conduct which hinders or distorts the competitive process. Courts largely understand that offering free product is no exception from antitrust scrutiny or liability, and instead focuses on broader conceptions of competition such as quality, consumer choice, and innovation. In doing so, their analysis goes far beyond the simple consumer price analysis. I know that there are several proposals being considered by this subcommittee. There are just 3 that I'd talk about briefly. One is in the merger acquisition burden issue.
And Mr. Attorney General, if I could ask you, I hate to interrupt you, ask you to wrap up. Your time has expired, but if you can make some concluding remarks. We'll get to ask you lots of questions.
Mr. Chairman, I will go ahead and wrap up with that and just simply say that I think with regards to the tech platforms and what we're seeing today, they're moving quickly. They're gathering a lot of data and market dominance. And I think I appreciate what this committee has done to address this. And I think the discussion, dialogue will need to continue to be at the forefront. Thank you.
Thank you, Mr. Attorney General. Thank you to all of our witnesses for your very important testimony. We'll now proceed under the 5-minute rule. I now recognize myself for 5 minutes. Chairwoman Slaughter, thank you much for appearing before us today. I'm in strong agreement with your testimony, and I appreciate it very much. I want to begin by asking you about the recent report by Politico about the Commission's decision to close the Google investigation in 2013. And even though I know you were not at the Commission at the time, I think it's important for us to understand what happened. One of the things that I find most alarming about the report is how the FTC completely ignored direct evidence of Google's anti-competitive conduct. Google favored its own properties, suppressed actual and nascent competitors, paid billions of dollars to be the default choice for mobile search, and deployed other exclusivity provisions to own the market, as one of Google's own executives described it. In sum, they paid exorbitant amounts to lock up the search market on desktop and mobile, reinforcing the moat around Google's business and devastating competition online. But instead of acting on this very serious threat to competition, the Commission chose to do nothing. As has become the hallmark of economic and legal analysis during this period, the agency vastly overstated the likelihood of entry by firms capable of challenging Google's dominance and discounted the likely harm to competition. But most importantly, instead of aggressively enforcing the law, the agency ignored contradictory evidence and blindly adhered to a misguided view that markets self-correct. This is not good economics, and it is not good lawyering. This misguided approach was also at the heart of the Commission's decision to close its investigation of Google's acquisitions of DoubleClick and AdMob, decisions that were bad at the time but look even worse now. There is something very wrong with this picture. And so, Chairwoman Slaughter, don't you agree that we must never let this happen again? And what can we do to ensure that enforcers are following the facts rather than ignoring evidence or relying on faulty market predictions? Do we need new laws, or do we need deep internal reforms at the agency, or both?
Thank you for the question, Mr. Chairman. And yes, I agree. We want to make sure that our enforcement is as effective as it can be. Look, I wish a complaint had been filed at the time, but I think it's important to note that many of the issues that were in the FTC's investigation are very much at play in the case the DOJ and the states have filed right now at Google and with Google. And I think it's great that our sister agencies are taking a hard look and bringing these hard cases. I also think it's incumbent on the FTC to bring hard cases. And I think in all areas, not just in tech, not just in platforms, we need to go back and take a look at our past analysis, figure out where our analytical tools are lacking, where our predictions were wrong, and what we need to do better going forward. That's very much something I'm committed to. And consistent with my testimony, I think there's work that the agencies can do in that respect, and I think that there is work that Congress can do to help us in that area. I think that one of the key points that you and several other witnesses have raised is the question of error risk. Do we stay being worried about the risk of over-enforcement, which I think has been a guiding principle for a long time, or should we focus more on the dangers of under-enforcement and the dangers of inaction? I'm very much in the camp where I'm concerned about the dangers of inaction and under-enforcement, and addressing that is a priority for me.
Thank you very much. General Weiser, thank you again for appearing today, as well as for giving your excellent briefing to us at our field hearing in Colorado last year. As I noted in my opening statement, the Clayton Act's prohibition on mergers that may substantially lessen competition is concerned with probability, not certainty. That's important because, as you have noted, it's a lot easier to prevent monopolization at the outset by blocking a merger versus bringing a complex case years later after the damage is done and impossible to undo in its entirety. So, General Weiser, my question is, what recommendations do you have for modernizing merger enforcement to address this concern, as well as strengthening the law with respect to nascent and potential competition?
Thank you, Mr. Chairman. It's a pleasure to be with you again. Let me take your second question first. I do think, and this picks up what Chairwoman Slaughter just noted, the fear of taking on these nascent competition cases has been a barrier to action, and we are worse for it. When there's a dominant firm, I do believe there should be a presumption that acquiring a would-be rival who could threaten that firm's dominance is a violation of the antitrust laws. That is a position for which I believe there is potential support in current law, but I also believe clarification of that principle would be important. We also need the encouragement, as my prior speaker just said, for taking these cases on. And unfortunately, there were some cases, I think there were bank mergers that didn't go well in this doctrine, and fortunately, antitrust enforcers stayed away. On the more broad point, I would say the merger guidelines that were done in 2010 are important in setting up the structure for merger analysis. And you put your finger on a fundamental principle, which is called in the world of antitrust, the structural presumption. When we begin to see markets and we lose 4 viable competitors, we start to see bad things for consumers. In airlines, that's the reality. We have 4 major nationwide entity providers, but almost no market has actual 4 major providers of airline service. We're now working with mostly 2, which lends itself to coordination and which is not good for consumers. So we need to see more vitality for that structural presumption and really put the burden of proof heavy on would-be merging firms who want to overcome it, not to essentially allow the enforcers to get spooked by undue or artificial burdens.
Thank you very much, General. I now recognize the ranking member of the subcommittee, Mr. Buck, for 5 minutes.
I thank the chairman, and I'd like to recognize Mr. Fitzgerald, or I'd like to have the chairman recognize Mr. Fitzgerald and then ask questions at the end if that's permitted.
Of course. Mr. Fitzgerald, you're recognized for 5 minutes.
Thank you, Mr. Chair. Commissioner Phillips, last September, the FTC issued a notice of proposed rulemaking that would provide 10% de minimis exemption to investment funds and master limited partnerships. Any idea when that rulemaking is going to be completed?
Mr. Fitzgerald, thank you for the question. I don't have an update on timing. Because it's an ongoing rulemaking, I have to be careful about what I can and cannot say. I did write in a statement that accompanied that notice of proposed rulemaking that 10% exemption, taking out from what we do transactions that over 40 years we have never challenged one, transactions that no one has made an argument are anti-competitive, would be a good way to allow the market to continue to function, allow the securities markets to continue to work better, and save agency resources. Again, in 40 years, we've never, ever brought a case on one of these transactions. These are not mergers in the colloquial sense. These are equity purchases. Oftentimes, they're by index funds or other investors. And I do think, as I wrote in my statement, subject to what input we get in the rulemaking process, of course, we want to look at that evidence, I do think going in, it's a good idea.
Very good. Thank you very much. Chairwoman Slaughter, you mentioned in the past that you want more effective enforcement of vertical merges. And I'm just wondering, can you kind of point to what you mean by that? And also, can you explain why you think some of those may be anti-competitive?
Thank you, Congressman, for the question. Yeah, so I think for a long time, there has been a general sense in the antitrust world that vertical mergers are rarely bad and, in fact, maybe mostly good. And this assumes some benefits to those mergers that I'm not sure are supported by the evidence. And in fact, the concern we have in verticals, or the concern I have in verticals, is where the manufacturer of an input and its downstream customer, one of its downstream customers merge, then that manufacturer may be inclined not to share that input with other customers. So I'll give you an example of a case that we worked on that the FTC worked closely with Attorney General Weiser's office on, which was a health insurance company that purchased a physicians group. And the FTC ended up taking a consent on a horizontal element of concern in that case, but didn't have a majority to support action on the vertical theory, which was about protecting consumers basically from physician price increases and making sure that they still had access to physicians through their health insurance, and working with the FTC staff, Attorney General Weiser was able to pursue a remedy on the vertical theory there that I think was really important for protecting consumers in Colorado.
Yeah, and I just because I only have a minute here, is there specific examples, and you may not have those at your fingertips right now, but love to see that as the subcommittee kind of moves forward and takes a little bit harder look at this.
Sure, I'll give you another example of a case that concerned me. We had a case involving a kidney dialysis company that ran a lot of clinics and purchased a company that made home dialysis equipment. And the concern there is once the company that that runs clinics owns the technology that would take patients out of clinics and do home dialysis use, are they really going to have the incentive to supply that technology to the market if it draws away from their clinic business? That's a concern for patients for some real access to real life-saving medical technology. So that's one example, but we'd be happy to work with you to get more.
Okay, thank you very much. Mr. Chair, I would yield back.
The gentleman yield back. Now recognize Mr. Jones from New York for 5 minutes.
Thank you, Mr. Chairman, and thank you to the ranking member as well for your leadership, sir. I'd like to thank our esteemed witnesses for sharing their expertise with us this afternoon. In our democracy, no one should be above the law, not the president, not any of us in Congress, not the world's biggest corporations. But today, unleashed from competition and from antitrust enforcement, the monopolies that dominate our economy are increasingly above the law. On one hand, these monopolies have become too big to govern. They know that if they violate our laws, they probably won't be held accountable. And to them, the penalties for breaking the law are just the cost of doing business. On the other hand, these monopolies are so big that they have the power to govern us. They force us to ration life-saving medications like insulin, set the wages for working families, and choose which small businesses live or die. They decide whether their workers will face exposure to COVID-19, and they decide when their workers can use the bathroom. They can fire almost anyone for almost any reason, but these corporations themselves can break the law with impunity. They even evade regulation by this body, until now. We would never give our elected officials unlimited power and blindly trust they'll use it for the best. We compel them to compete for our votes, and we limit their power with checks and balances. Our economy should be no different. We need competition, we need checks and balances, and stronger antitrust laws must be part of the solution. Judge Wood, it's an honor to speak with you this afternoon. I used to work with someone at the Justice Department who even then sang your praises, so it's a pleasure to finally make your acquaintance. You testified that our antitrust statutes were created to protect consumer welfare and to prevent, quote, concentrated economic power. How has the Supreme Court made it harder for the FTC and the Department of Justice to challenge unlawful concentrations of economic power?
Well, thank you very much for the question. It's really a privilege to be here, and it's a privilege to meet you as well through Zoom. The Supreme Court, since the mid-'70s, really, I date it to 1974, has accepted what General Weiser called the Chicago School approach, which I think is a little over-inclusive as a name, since I'm from Chicago and it's not my approach. But they've said the only thing to worry about is high prices for consumers or restrictions of output. And the court has over and over again recited this phrase: the antitrust laws are for the protection of competition, not competitors. So exclusionary practices that pushed a competitor out of the market, often in a vertical setting, were blessed by the court. The court said there was no violation. That's how they understood the statute. You know, and the Supreme Court's doing its job to interpret the statute, but Congress also has a job to say, is this the statute we meant to have? And the other thing the court has done is it has really adopted this notion that the market will fix everything in the long run. And the analogy I would invite the committee to consider is one that comes from the merger guidelines. If you don't think that competition will be restored within about a 2-year period, you know, you're going to be really worried about that merger. And so, you know, I'll give you the example of Kodak, a monopolist for many years. We probably barely remember that it existed, but between 1925 and 1995, it had about 80% of the US film market. Well, that's a long time to wait for the market to control things, for the market to correct things. So my suggestion to the committee is it might, in these monopolization cases, put in a requirement that's like the 2-year requirement in merger cases. If you think that the monopoly will start breaking down because there's open architecture, because there's interoperability, then maybe you don't need to worry about it. But if you think it's going to be persistent, that's a different story.
And if Congress believes that the Supreme Court has misinterpreted these statutes, doesn't Congress have the power to correct that misinterpretation? Specifically, the power to ensure the FTC, the Department of Justice, and private plaintiffs can hold corporations accountable?
Congress absolutely has that power. And as I was suggesting, I can think of other areas in which Congress has exercised it. Think of the Lilly Ledbetter statute that was passed when the Supreme Court gave a very narrow interpretation to the Civil Rights Employment Discrimination statute. Think of the Americans with Disabilities Act. Congress can step in whenever it wants to with the statute and either change it or correct it or whatever it wants to do.
Thank you, Mr. Chairman. I yield back.
The gentleman yields back. I now recognize Mr. Bentz from Oregon for 5 minutes.
Thank you, Mr. Chair. So, Mr. Phillips, every law has to have a limiting principle. Otherwise, it's not a law, it's a license to be subjective. So, in fact, what we end up doing is outsourcing its enforcement to perhaps bureaucracies. Thus, if our antitrust laws were expanded in scope of purpose, say to add to consumer protection, such things as independent businesses, fair economy, and other things, to name a few, what does this do to you in the regulatory realm?
Thank you, Mr. Bentz, for that question. I'd say in the main that the old expression, he who serves two masters serves none, is an important one to keep in mind. The more things we're directed to do simultaneously, the less we focus on any given one. So clarity in law and administrability is really important for making us efficacious in our work. The more different things you add, the worse off we are. Now, as I said in my testimony, what we do today, the consumer welfare standard that the Supreme Court has recognized, isn't just limited to price. So for instance, if you don't have price competition, there might be other aspects of competition that are affected. And it is important to note that today, in litigation, we look at those other things too. So we will allege price harms, but we will also allege innovation harms and so forth. And that is how we do it today.
And continuing with you, the principles of antitrust law have evolved over 100 years, I suppose. And people have become reliant upon them, build their businesses around them. If we choose to change those, what impacts do you anticipate? If we change them significantly, perhaps even dramatically?
Yes, so I think it really depends on what changes we make. And that's why this discussion that we're having today is so important. Part of what makes America great, part of what has allowed our economy to be as innovative as it is, more innovative, by the way, than other jurisdictions that have more restrictive laws, is the fact that we have still today a vibrant investment environment. People know maybe they're gonna bet on a unicorn and make a lot of money, but if they don't, they can still make money selling out, including through M&A. Founders know that when they go and leave a steady job to start a company, they've got a chance of making some of that back. That's an important ecosystem that we need to consider as part of this discussion.
And pursuing you with one more question, the complexities of this area are truly amazing. And when one goes into litigation, it takes years. Is that a function of just a poorly designed system, or is it a function of the incredible complexity of the businesses we are now dealing with?
I think it's a mix of things. The truth is the problems with antitrust litigation in terms of cost, and they are real, and it's why I support more resources, aren't just about antitrust. If you think about securities litigation or corporate contract litigation, you're also hiring economists, you're also spending a lot of time to figure things out. But a lot of the most effective work that we do today, and this is important to recognize, and it goes, by the way, to nascent competition, is before the litigation starts. So for instance, in mine and the acting chairwoman's tenure, we have challenged 3 examples of nascent competition. Big established firms buying smaller ones. We've brought complaints. We've used the merger laws. That's the Clayton Act. We've used the Sherman Act. We've used the monopolization laws. We've gone to court and they've called off the mergers. And that's a good outcome for consumers. I think it's a good outcome for enforcers as well.
In the limited time left, how should the law distinguish between conduct that harms a competitor from conduct that harms competition?
Sure. What we look to protect is the competitive process. There are times when one firm outcompetes another. And that hurts the other firm, and that's not necessarily bad. And that is the distinction that that phrase draws. Sometimes it doesn't sound so meaningful, but the point is we want people to benefit from the fruits of competition. We don't just want, as sometimes happens, companies to come in and complain that they're being beaten in the market, and they want the government to go make it right for them.
Thank you, Mr. Phillips. Mr. Chair, I yield back.
The gentleman yields back. Now recognize the gentleman from Colorado, Mr. Neguse, for 5 minutes.
Thank you, Mr. Chairman. I want to say again, thank you for holding this hearing to examine ways that Congress can improve and strengthen antitrust laws, not only for the digital marketplace, but across our economy. There's clear bipartisan support, in large part due to the chairman's approach to this subcommittee's investigation with respect to the digital marketplace, that Congress should construct a broad and comprehensive range of reforms to modernize the antitrust laws and protect innovation. And I thank him for that work. And of course, to the distinguished panel that's joined us both virtually and here in person. Commissioner Phillips, do you believe that the FTC's approach to pharmaceutical mergers is working?
Forgive me, Congressman, thank you for the question. My view, some have suggested that it isn't. And what I am interested in hearing is what are the harms that folks think we're missing? Because I think if they exist, we should figure out what they are, figure out how to build a case on them, and bring those cases. That's why I support the chairwoman's effort to convene a group of enforcers. I think there are other enforcers we could convene as well to think about what those additional what those additional harms may be.
Well, so let me say this, and I appreciate your answer, and I appreciate you being candid with respect to your views. It sounds like you believe that they are working, that the policies that the FTC has pursued with respect to pharmaceutical mergers have been effective. I don't think that's the case. I happen to agree with the dissenting view that was issued back in last November of 2020, and I think the empirical evidence bears that out, with a market that is highly concentrated and an American public that's paying higher prices for pharmaceutical drugs than any other Western country. And clearly, it is an area that is ripe for the attention of regulators, which is why I am, I guess the one thing we do have in common, Commissioner, that I do share your enthusiasm for the chairwoman's decision to convene this working group, because I'm hopeful that it will provide some potential best practices that the FTC could implement. And so to Commissioner Slaughter, Acting Commissioner Slaughter, as you noted in your prepared testimony, the FTC announced this multilateral working group to build a new approach to pharmaceutical mergers, which is something I fully support. You've, of course, expressed the dissenting opinion that I referenced was yours. Your view as to the FTC's failings in this regard. I wonder if you can kind of expound upon both what you hope to achieve through the working group and perhaps expound a bit on the concerns that you articulated in the dissent that you issued, which I certainly fully agree with.
Thank you so much, Congressman, for the question and for the support you have articulated for our initiative. I'm really excited about it. I am really excited about the opportunity to take a fresh look at a broader range of questions in pharmaceutical mergers than our traditional approach has taken. And some of the issues I want to make sure we think about are innovation broadly, not just in terms of specific products and pipeline products, but when two large pharmaceutical companies merge, what does that do to their R&D budgets? What does that do to the incentives to bring new unrelated products to the market? What does it do for the incentives for venture capitalists and entrepreneurs to invest in small biotech startup companies that could bring new products to market that might have to be scaled up through larger companies at some point? Another area of concern for me has to do with conduct. We have an entire division of the FTC that's devoted to anti-competitive conduct in the healthcare industry, and much of that attention is focused on the pharmaceutical industry. So when two large companies with histories of anti-competitive conduct merge, what happens to their incentives to engage in that conduct? That's something that I think that we need to be looking at. And the goal of this initiative is to put concrete theories and concrete examples of evidence that we can give to staff, because it is true, when we bring cases, they are specific cases that we have to prove in court. And I want our staff to be armed with the best tools to do their investigations as thoroughly as possible, address all of the potential theories, and bring cases effectively. So that's one thing I'm excited about. And the other thing I'm really excited about is the opportunity to partner with sister enforcers and other great thinkers on these issues across the globe. The list that we started with is by no means an exclusive list. I'm sure we'd welcome participation from other players, but I agree with what Attorney General Peterson said earlier and Attorney General Weiser reflected, which is that enforcers are stronger when we are working together and partnering on issues and working in harmony. And this is a great example of an opportunity to do just that.
Thank you, Commissioner. And I have 2 seconds left here. The chairman's courtesy, I would simply say I want to give kudos to the attorney generals, and in particular, my attorney general from the state of Colorado, for their efforts. And I think what you hear is a bipartisan sense of gratefulness from this committee for your willingness to take on these very tough issues. And with that, I would yield back.
The gentleman yields back. I now recognize the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. And I want to piggyback on a lot of the discussion about why particularly tech companies do acquisitions in order to close off competition. But I want to take it in a slightly different direction, if I may. Closing off competition can be done in a number of ways, and in fact, ensuring a dominant position in a number of ways. And I want to switch now to standard essential patents. I come from an industry many years ago at this point, the electronics industry, where almost everybody who has a patent would like to have their patented technology put into a standard that then everyone must use and pay for. This has happened certainly in the telecommunications industry for years, but we see it happening in bio and other areas in a greater amount. And so the question primarily, I'll take it from anyone, but Acting Chairwoman Slaughter, I'd like to start with you. Do you have the authority to effectively stop that practice from turning into either revenue and thus perpetuating the dominance, or other tools, or do you need Congress to give you additional tools that would allow you to stem the profiteering from that way of doing business? And it'd be for Slaughter or the Commissioner.
Thank you for the question, Congressman. And I will note that both Commissioner Phillips and I had the pleasure of working with your office on patent issues when we were Senate staffers together. So I'm always excited to talk about these issues with you. I think that to the extent that what you are pointing out is that patent, and particularly a standard essential patent, conveys enormous market power, it is a really important issue. Standards are good. They allow broader innovation and implementation, and that's great. But we want to make sure that that market power isn't abused, and that when your patent gets included in a standard, that you follow through on the commitment to license that patent at a fair, reasonable, and non-discriminatory rate, so that your market power from your inclusion in a standard on which many implementers read doesn't allow you to exclude competitors from the market. And that's different from the way we traditionally think about patents, which are really rights to exclude. So I think there is a role for antitrust law to play. I think there are many ways in which I think that we could be better enabled to address competition problems, and I've outlined some of them in my testimony, but I think this is an important issue for us to continue to focus on.
And while I let Commissioner Phillips answer also, I'm going to put a hypothetical. Congress could determine that when a product with the approval of the patent holder becomes a portion of a standard and thus an essential standard patent, that the standard for reimbursement and exclusion could change from the right to exclude to eliminate the right to exclude altogether, and from a reasonable royalty to a diminished reasonable royalty based on what would have been the revenue if it were not a standard, and then divided more broadly since it is a standard. In other words, not allow the enrichment of everyone using it to logarithmically, in some cases, increase the revenue. Congress could certainly determine how that calculation would be made so as not to unfairly enrich somebody who chose to have it put into a standard while having it patented, and often patented again and again and again over the years. But please, Commissioner.
So first of all, I just want to echo the acting chair. I recall very fondly the work we did together on patents.
Back when we used to get new patent law made, right?
Well, this is actually really important. You know, the original monopolies were issued by the English kings in letters patent. And so the original concept of a monopoly, right, is a government grant of only you can be in that market and you can derive the rights. And our founders wisely determined that we should only grant that for the purpose of science, progress, and the useful arts, right? That's in the Constitution. And there are many areas, including, as Mr. Neguse was talking about, with pharmaceuticals, where not only antitrust policy, but other aspects of policy come to play. But the answer to your question, fundamentally, is absolutely. Congress determines the antitrust laws, but more critically, for purposes of the question, they determine patent rights. One thing I would note is when the FRAN process is perverted, as in the Rambus case, we have used antitrust law.
Thank you. Thank you, Mr. Chairman.
The gentleman yields back. I now recognize the gentleman from California, Mr. Swalwell, for 5 minutes. Mr. Swalwell? No? All right. I now recognize the distinguished gentleman from New York, the chairman of the House Democratic Caucus, Mr. Jeffries, for 5 minutes.
I thank my good friend, Chairman Cicilline, for yielding, recognizing me, and for your incredible leadership and putting together such a distinguished panel on this important subject. Attorney General Weiser, it's good to see you. The state of Colorado has joined the antitrust lawsuit led by New York State Attorney General Tish James against Facebook. Is that correct?
That is correct, Congressman.
And that lawsuit alleges that Facebook has engaged in a pattern of either burying or buying competitors in violation of our nation's antitrust laws. Is that true?
That is true.
And there's evidence that Facebook has sought to bury competitors such as Vine and Circle. Is that part of your lawsuit, sir?
It sure is.
And Facebook has also bought competitors like Instagram and WhatsApp. Is that true?
Yes, it is.
Now, it's my understanding that you're a Colorado Rockies fan. Is that correct?
That is correct, although with respect for you and Congressman Jones, I did grow up as a Mets fan, and it's hard to get rid of that.
Yes, I appreciate your clarity there. I was a little bit disappointed when I heard the news because I know of your New York roots. But Major League Baseball would never allow the New York Yankees to purchase and merge with the Boston Red Sox. Is that right? Is that fair to say?
I don't think there's ever been a merger of two baseball teams before.
Right. I mean, that would create an anti-competitive environment, true?
Absolutely. I did grow up a Mets fan, so I'm remembering 1986 fondly when it comes to the Red Sox.
Yes. Now, I don't think the NFL would permit the Kansas City Chiefs to merge with the Tampa Bay Buccaneers, correct?
I don't believe so.
And it would seem to me impossible to see a scenario where the NBA would allow the Lakers to merge with the Boston Celtics because of the fundamental unfairness that that would create. And so I'm just trying to figure out from your perspective, why in the world would our laws permit Facebook to be able to purchase a competitor like Instagram, possibly to the detriment of the U.S. consumer?
The answer gets to the prior conversation I was having with the chairman, which is when a rival is still nascent, the ability to show that it is exercising a true constraint, particularly when it's a market like this one where prices aren't an issue, it's very difficult to do that. And so the antitrust laws, as they've been implemented, provide almost an incentive and an opportunity for dominant firms to keep a lookout for nascent rivals and purchase them before it's self-evident that they are in firm competition. And what we can say clearly looking back is that Instagram and WhatsApp presented unique, clear, and significant threats to Facebook, and they were able to purchase them and thereby avoid the sort of rivalry that we depend on in a free market system.
Thank you. Acting Chair Slaughter, prior to your tenure at the FTC actually approved that merger between Facebook and Instagram. Why were our laws insufficient to see what was coming, and what should we contemplate changing in order to facilitate the type of competitive playing field that we expect in sports and should expect to see as it relates to big tech?
Thank you so much for the question, Congressman. So I want to point to one word that you said in that question, which is that the FTC approved these mergers. And it's worth remembering that our laws don't actually give enforcers the authority to approve mergers. It is not the case that but for our approval, mergers would not go through. In fact, it's the opposite. We have the opportunity to investigate mergers before they are consummated if they are large enough to merit an HSR filing. And then if we think that they might be a problem, we have the opportunity to go to court and try to block mergers and convince a court that the merger would be anti-competitive. And for the reasons that Attorney General Weiser pointed out, that can be a challenging endeavor in the case of a nascent competitor. But I think it's an important thing to remember where that balance lies in the laws as they are structured right now in terms of acquisitions. I think it's also important to know that the law does not stop after an HSR filing passes and the waiting period elapses or an investigation is concluded. The law gives the agencies the authority and I think the responsibility to continue to check their work and where it is appropriate, take action if it becomes clear that a merger was anti-competitive. And that is exactly what the FTC did in filing our own lawsuit against Facebook in parallel with our partners in the state attorneys general's offices.
Well, thank you, Madam Chair. My time has expired, but I look forward to working with Chairman Cicilline and Ranking Member Buck on these issues, including updating the Clayton Act. I yield back.
The gentleman yields back. I now recognize the gentleman from Florida, Mr. Stubbe, for 5 minutes.
Thank you, Mr. Chairman. Recent actions by big tech companies and their online platforms require action by Congress. These companies have censored political debate in this country and restricted competition. The most direct way to alleviate this growing problem is not through antitrust measures, but rather by amending Section 230 of the Communications Decency Act. The extraordinary protections of Section 230 should be contingent upon big tech allowing free and open speech on their platforms. We can immediately address big tech censorship through Section 230 legislation. I urge my colleagues to support this effort. To the extent that federal antitrust laws can address these issues, it's important that our approach is not overly broad and does not hinder state efforts to rein in big tech monopolies. My first question is for AG Peterson. To the extent antitrust laws can only partially bring big tech to heel, what role do you think state consumer protection laws should play, and how about reforms to federal laws such as Section 230?
Well, I think it's a good question, and frankly, it's a question that's being discussed by several attorney generals as the utilization of our consumer protection laws and some of the practices that we see. Actually, the Section 230 issue is obviously a much more complicated one. But from the consumer protection standpoint, and frankly, the FTC has some of the same jurisdiction. I can't go into any further detail, but all I can say is that there is a discussion in regards to how we can be more diligent about following the platform practices and how they may be in violation of consumer protection laws.
It seems like exercise of big tech's power is having increasingly disproportionate impact on culture and society because of the power that certain big tech companies have. Instead of open and rigorous debate, voices that take traditional views are increasingly being canceled. What role, if any, do you think aggressive state antitrust enforcement might play to help foster a more vibrant marketplace? AG Peterson.
Well, what I would say is in the discussions among AGs in addressing the market dominance by some of the big tech companies, Frankly, it's been very important among the AGs in order to have a bipartisan coalition to stay as focused as possible on competition factors and anti-competitive behaviors, which does not get out into the political speech issues. And I think we lose part of our coalition if we do try to address any of the political speech issues with the antitrust laws that we're utilizing.
Commissioner Phillips, speaking of the unintended consequences of tinkering with well-established antitrust laws, what guiding principles can Congress adhere to in order to make sure that any action we take in regards to tech and antitrust does not end up being a total revision of antitrust laws in this country?
Congressman, thank you for the question. I think the two most important things to keep in mind are first, that when you are thinking about things like presumptions, you should look for data to understand that the thing you're targeting is more bad in general than good. So here's what I mean. In antitrust law today, right, we have a structural presumption for mergers that we apply in court. We have presumptions, what we call a per se rule. So if you're fixing prices or dividing markets, doing things that we know in general are bad, enforcers and private plaintiffs get a leg up. We're doing a study right now at the FTC of acquisitions by large tech companies. To be clear, there are other large companies that also make acquisitions. And what I think you want to think about when you think about presumptions is, what do the data show? So that's the first thing. What do the data show? The second thing, as you noted in your line of questioning to Attorney General Peterson, antitrust is not designed to and will not be effective at solving every problem. Some of the problems that we're talking about don't have to do with antitrust, and the tools we have aren't effective at doing them. And I'll give an example. Like we were talking about content moderation, and what platforms are doing with speech. That's I see platforms make decisions that I really don't like, but I also see smaller companies doing that too. So it's harder for me to see how Twitter has market power, but that doesn't mean they're not making decisions that I don't like. Antitrust is not the solve for everything, and I do think it's really important to figure out what the problem is we're trying to solve and figure out the right tools to solve it.
Well, and along that lines, and I only got a couple of seconds, but what are the dangers of amending antitrust laws to try to address problems unique to only a certain industry like tech companies?
Look, I think you always want to work with a scalpel. One of the great things about the antitrust laws is that they apply broadly and they embed critical principles. Don't divide markets, right? Don't set prices. And that's good. I think a lot of the other problems relate to other things.
Thank you. My time has expired.
The gentleman's time has expired. The gentleman yields back. I now recognize the gentleman from California, Mr. Swalwell, for 5 minutes.
Thank you, Chairman, and really appreciate your interest in this area. I have to say to the panelists, I hope we can do this in a bipartisan way. I hope we do not conflate the so-called cancel culture concerns of my colleagues with real reforms that need to be made. If they have real concerns about cancel culture, I would suggest that their next minority witness be Colin Kaepernick. I think he would have a few things to say about them and cancel culture. But let's get on to serious business because we have serious matters to address. And Acting Chairwoman Slaughter, I think you could talk about antitrust cases as being notoriously expensive and taking years to investigate and litigate. In some cases, we've seen judges just completely exasperated at the time and expense that plaintiffs and defendants invest in after teams of experts and lawyers are involved. Can you talk about whether you see like maybe a third way rather than going through the full course of litigation? When I was a prosecutor, if we wanted to avoid a lengthy trial and a lengthy period of time in between litigation and a verdict, sometimes we would offer a deferred sentence, meaning if the parties agreed that they had to do A, B, and C, you wouldn't have a trial. Is that a possibility here to avoid, kind of an all or nothing approach?
Thank you so much for the question, Congressman. And I think that, so two things I'd say. First, you're absolutely right about the expense in terms of both time and money to engage in the kind of battle of an experts that we see in antitrust litigation right now. I will just point out, since I talk about resources all the time, it's worth noting that one of the real squeezes on the FTC's enforcement budget right now is the cost for us on economic experts. It makes it really hard to bring cases. They are expensive, they are time consuming, and they really squeeze our budget. To the extent that you're talking about a third way, it sounds to me like what you're talking about are settlements. And I think settlements have a really valuable role to play to the extent that they actually solve the competitive problem about which we are concerned. My anxiety comes into play when we take settlements just to defer lengthy litigation and we don't actually solve the problem. And the settlement is something that maybe papers over or requires ongoing complicated monitoring or is difficult to administer and isn't a clear solution to the problem. So I'm all for settling where we can do it in a way that addresses the issue that we have, but I would rather see us go all in on litigation, even risky and expensive litigation, if that's the only way to solve the problem. I do think the way we could avoid that cost is in some of the reforms that you're considering that would do some burden shifting or add presumptions so that we don't have to do as much and judges don't have to spend as much time engaging in this tortured battle of the expert and extensive analysis to balance harms and efficiencies all the time.
Chairwoman, talking dollars and cents, what do these costs mean for those types of cases? Are there instances where anti-competitive conduct or illegal mergers that the FTC would typically want to bring enforcement actions against are not pursued because of budget constraints?
Well, listen, I'm not comfortable saying we're going to forego enforcement action because of budget constraints. And even before we had visibility into what our budget would look like this year, in December, I think we filed 4 separate enforcement actions in that month alone because it's important to go at it. But we're looking at ways to cut those costs. And if we can't make sure that our resourcing keeps up with the costs of litigation and, more importantly, the demand on the agency, the very, very high volume of anti-competitive transactions that we're seeing, then foregoing enforcement is a real possibility, and that is a very unsatisfying one to me.
Great. Well, thank you so much, and I yield back.
The gentleman yields back. I now recognize the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Chairman Cicilline. I appreciate that. The chairman mentioned, I think, the same article. I'm holding a Politico article that's titled "How Washington Fumbled the Future" by Leah Nyland, dated March 16, and I'm taken with it as the chairman is. Have you had occasion to read that article, Mr. Phillips?
I have read the article, yes.
It tells a story in which the lawyers are the heroes, and perhaps it deserves some skepticism on that basis alone. But I wonder, it depicts, if I can summarize, I think that FTC had an enforcement failure in 2013 in evaluating Google, and it depicts disagreements between economists and lawyers, particularly in the agency. Was there an enforcement failure there in your view, or do you have insight about that?
So Congressman, I think about 2 years ago, I read portions of some of the memos discussed in that article, but I have not read all of them. I have not been briefed by staff in any substance on the case and what on. To be clear, this was years before my tenure, and I haven't reviewed the evidence, so I don't want to weigh in on the particulars. What I will say is this: the agency benefits from the robust conversation between economists and lawyers. And to be fair to the economists who took a little criticism, our hospital enforcement today is built on the work that they did, building a model and explaining to courts for why hospital mergers can be problematic. So I think we benefit from that input. But the answer is, when it comes to antitrust, when it comes to merger enforcement, it's future looking. You, Congress, have told us to look into the future and make our best guess. And we do that. We're not always going to get it right. And to be clear, in the history of American antitrust enforcement, not only people not wanting to bring suits have gotten things wrong, but also people wanting to bring suits, right? So America once believed that mainframe computing would be the only game in town. No one does that anymore. What a lot of people you've heard today talking about, and what I think is a change that is ongoing already at the agencies, is that when we look at a merger, in particular, let's say a merger of a nascent competitor, we're a little bit less concerned with the risks of over-enforcement and a little more concerned about the risks of under-enforcement. I think that change is underway today. I think that's why, with my colleagues, I voted for 3 of these cases, including a platform case. That's the Illumina PacBio case, the gene sequencing platform. That's why the DOJ brought the Sabre case. That's why they brought the Visa Plaid case. The reason you're seeing more of these cases is we are hearing the message and we are concerned about this dynamic.
So you said something else that is interesting in your answers to Mr. Stubbe. And that was, I think a lot of folks here who are very concerned about the censorship, Mr. Swalwell made light of it, but I'm very concerned about it, the censorship by tech giants acting together, that the problem there is a lack of competition. There's market power, concentration of market power. And you said that antitrust can't solve every problem, and we may need to look elsewhere. Can you elaborate on that? I mean, why would it, if it seems to me to be a problem of a concert of action by 5 big tech oligarchs, then why isn't antitrust the solution?
Well, part of what I mean, thank you, Congressman, for the question, is that some of the behavior is governed by, the First Amendment. So content moderation decisions ultimately are governed by that. But the other point I was trying to make is these, and I watch some of these decisions and I don't like them, but it's not clear to me that it's an exercise of market power, which is what we're trying to police. So we do see some problematic instances with large tech platforms, but my point is we also see problematic instances with other kinds of companies. So I'm not sold on the notion that this is an antitrust problem.
Well, I think the problem that maybe confounds some of us is that the other place to go, it seems, is Section 230 of the Communications Decency Act, and it has sort of a meat cleaverish approach or significance that if this business model has been allowed to exist by virtue of the moderation that's allowed under that provision, and so some desire to figure out how to fix it by invigorating competition. I guess your point is that you can do as much harm as good if you don't do that right.
Yeah, again, I also am not sure that this is sort of a manifestation of market power. The issue of content moderation, which is terrifically hard, and you're right to note the complexities, and to be clear, I don't have a great answer on this, is a problem of allowing speech in effect at scale and the decisions that companies have to make. And sometimes it seems to me like they're stepping on rakes, right? Someone will call something to their attention and they'll take it down. It's just not clear to me that it's a manifestation of market power.
Thank you, sir. And Mr. Chairman, my time's expired. I wish I could have gotten to Chairwoman Slaughter, but I didn't. Thank you.
The gentleman yields back. I now recognize the distinguished gentleman from Maryland, Mr. Raskin, for 5 minutes.
Mr. Chairman, thanks to you and Mr. Buck for your great leadership with these hearings. Judge Wood, I wanted to come to you. We often trace the antitrust laws to a century or a little bit more ago, with Sherman and Clayton and so on. But wasn't the anti-monopoly principle, in fact, something that the framers of the Constitution themselves talked about? Didn't Jefferson actually want an anti-monopoly amendment in the Constitution? And doesn't it suggest that there are deeper political and philosophical roots to our antitrust jurisprudence?
Well, thank you very much. There certainly are. I mean, the antitrust laws did not spring out of nowhere. There had been the English common law of restraints of trade and notions of what fair competition was all about. And that had been done, of course, for a century at the state level. And the reason Congress steps in 1890 was, frankly, transportation, communication, all sorts of other things began to make it very easy for the Standard Oil Trust to be in Minnesota one minute and New Jersey the next minute and who knows where. So Congress said the only thing that's going to work is a federal approach. Then there's a period of time where the courts are trying to figure out, well, are you just codifying the common law or are you going further than the common law? And that's a longer discussion than we have today, but they certainly learned about the importance of competition from their forebears. As Commissioner Phillips said, there had also been the statute of monopolies in England, which led to our patent laws. And I might throw in a bid here for saying that if the committee is really interested in some of these difficult areas of dominance that are, say, in the pharmaceutical interest driven by patents and in other areas, one thing it could do is give authority to more courts to think about how patent law and antitrust law intersect. Give concurrent jurisdiction to the regular courts of appeals.
Well, let me pursue that for a second, if I could, Judge Wood. Well, what's wrong with the narrowed down consumer welfare utility approach to antitrust? It sounds pretty good just to say, well, if it lowers prices for consumers, then there can't be an antitrust violation.
It does sound good, but what it excludes is all sorts of behavior designed to push people out of the market. So take the airline example that General Weiser was talking about. If a newcomer decides to offer airline service between Chicago and Denver, and the incumbents all lower the price below cost, well, that's lower prices for consumers, and consumers probably like paying lower prices, but it drives the newcomer not only out of that market, but it also sends a very forbidding message to other newcomers that maybe they better not try this because they're just going to lose a huge amount of money and they don't have the staying power of the dominant firms.
So that's going to end up hurting the consumers in the long run when you get that monopoly power. But what else does it do to the economy or to our society to have just a few dominant players in each of these major industries?
I would put my finger on innovation, frankly. I think when you have only a few dominant players, there are just only so many brains looking at it. And we knew from the AT&T case, for example, that if you were the dominant player, you didn't have any incentive to get rid of your old built-out infrastructure and bring in something new and better. And so if you push out all of these competitors, whether through refusals to deal or exclusionary practices or, through tying arrangements or however you do it, then you don't get those new ideas. You don't have that ferment that we have relied on over the course of our history.
Can you describe how a revived essential facilities doctrine might help us to address the monopolization tendencies that are taking place right now?
Okay, so what I think of when I think of essential facilities is really the bottleneck monopoly. You have a firm that either gets all the control over an essential input or all the control over the essential patents, and then it just decides who it's going to let in. It's actually a little bit like the question we had earlier on standard essential patents. And I think maybe it's an extreme case of exclusionary behavior, but in my view, it is very effective at making sure you keep the market for yourself and you keep out those potential innovators.
Finally, very quickly, do you think antitrust law is a counterweight to the free market, or do you see it as the guarantor of a free market?
The second, I think it's the guarantor of the free market. It protects the competitive process, broadly speaking.
Thank you very much, Mr. Chairman. I yield back to you.
Gentleman yields back. I now recognize the ranking member of the full Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Mr. Phillips, if we're not going to use antitrust to deal with the censorship and you are reluctant to talk about 230, what's the answer?
Congressman, I'm afraid that I don't have a good answer for you right now. This strikes me as a terrifically problematic issue. My remit is antitrust and consumer protection, and it doesn't fall into those categories. Section 230 is a congressional statute, and that's something Congress can evaluate. But if I had a good answer, I promise I would give it to you.
Well, last fall, big media, we know this happened, big media colluded with big tech to keep a critical story from the American people, the story about the Biden family and specifically Hunter Biden and the fact that he was under investigation. We know that was a fact. We know everyone knew. We knew people in the press knew. And they kept that from the American people in the run-up to the most important election we have, which is a presidential election. And we're trying to figure out what we do to, last week we had a hearing in this committee where the chairman wants to give an antitrust exemption to the very big media who colluded to keep information from the American people. At the same time, they want to use antitrust to go after big tech. So again, we got to do something, it seems to me. Any thoughts on all that?
Well, the one thing I would say is if competition is the goal, and competition is the goal of antitrust, exemptions to the laws, right, permit companies not to compete, but to collude together. I don't think that that would help the dynamic that you're talking about.
Okay. And then, but what about 230? I mean, this is something that Congress can do. I happen to think, I mean, I've heard from Scott, I heard from Professor Dershowitz, who said, definitely we should reform 230. You're making content decisions on your platform. Your liability protection should be gone. I totally agree with that. I think that's something we can do. But you don't have a thought on that at all?
The troubling thing, Congressman, in my understanding, and I am not a Section 230 expert, is what I would like to see, right, is a flowering of speech. I think that's what we as Americans like. That's why we're concerned, right, when people kind of harangue other voices that they may not agree with out of the public square. The trick, I think, with Section 230 is how to fashion it such that that dynamic doesn't happen. Mm-hmm. I definitely worry, right, when it comes to strike suit litigation, that someone does something, someone fires a suit at them, and they take the content down. We don't want that dynamic either. Again, I'm not an expert on 230. That's the worry that I have.
Okay. I'll yield the balance of my time to the ranking member, Mr. Buck. Thank you, Mr. Chairman.
Unexpected generosity, thank you.
Anything, brother?
Commissioner Phillips, let me ask you a quick question here. Are you aware of any statutes passed by Congress? Well, you said earlier in your opening statement that the problem with antitrust revisions would be that they apply to the economy as a whole. I believe that's a fair summary, paraphrasing.
Yes, sir.
Okay. And are you aware of any statutes passed by Congress that targeted specific industries in the antitrust area?
So I think there have been some attempts at exemptions, and actually we were talking about sports earlier, and there are some sports that are exempt from antitrust. I'm not aware of a specific antitrust statute that targets an industry. There are obviously regulatory statutes that Congress has adopted.
Let me ask you this, are you familiar with the Hepburn Act?
I am not, as I sit here today.
Okay, so the Hepburn Act says that it shall apply to any corporation or any person or persons engaged in the transportation of oil or other commodity by means of pipelines or partly by pipelines and partly by railroads or partly by pipelines and partly by water. Would that be an example of an antitrust statute that targeted a specific industry and commodity?
It may very well be, and also I should add something. I even referred in my testimony to the Robinson-Patman Act, and that was definitely focused on the retail industry. So to the extent my answer was inconsistent with that example, forgive me.
And would there be anything inappropriate or improper, unconstitutional perhaps, with this committee recommending to the House, and if it passed the House and Senate, signed by the President, targeting big tech platforms because of their unique space in our economy right now?
So I think, Congressman, certainly there is nothing improper or unconstitutional that I can think of off the top of my head. Okay. Congress has power over interstate commerce.
Great. I yield back.
The time of the gentleman has expired, or the gracious gift from Mr. Jordan has expired. I now recognize the gentlelady from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman, for holding this very important hearing. When you drive a car, you typically assume certain rules of the road. These rules are there to protect people driving in different directions towards different destinations. Antitrust law used to abide by its own rules of the road, sometimes called bright line rules. If a merger risked concentrating too much power in the hands of a few firms that could then dominate an industry, regulators blocked that merger. They did that by setting clear thresholds. For instance, in 1968, two firms that each held a share of 4% or more in a highly concentrated market ordinarily could not merge without inviting a lawsuit. Today, antitrust law operates very differently. Now, corporations hire expensive economic consultants to help them argue in court that a proposed merger could theoretically in quotes, lead to lower prices for consumers. Studies show that these lower prices rarely materialize in practice, and the complexity of this so-called consumer welfare standard excludes low and middle income people who can't afford to hire fancy consultants, even if they face immediate harms from a merger, whether it's as consumers, workers, sellers, or community members. Chairwoman Slaughter, from your perspective as acting chair of the FTC, can you be specific about how enforcement under the current standard compares to the use of bright line rules for merger enforcement?
Thank you, Congressman, for the question. I think you pointed to exactly how it compares, which is that right now we have to engage in a very extensive, expensive investigation into and then argument about in court the particular harms. We have to measure them. We have to try to balance them against measurable efficiencies, and that is difficult. I think if we had clearer, bright line rules, we would absolutely prevent more mergers. If there is a risk to that, it is that perhaps we might block some mergers that might not be the worst mergers in the world. It would be an over-deterrence problem. I will tell you that as I sit here right now, given how far I think we've gone in under-deterrence, I don't lose a lot of sleep about the risk of over-deterrence.
Thank you, Chairwoman. And in your testimony, you state that the FTC must be bold in bringing cases where success in the courts is not guaranteed. Would the adoption of bright line rules for merger enforcement embolden antitrust enforcers to bring important cases to court? I mean, you referenced this. You said you don't think it's going to have that effect, but can you say more on that?
Well, yeah, I think it would make the cases less hard to litigate, which would mean that we could bring more of them. It would make the cases less expensive to litigate, which means we could bring more of them. I am focused very much on what we can do even now, even while Congress is engaged in this important effort to reform the laws. But I am excited about the idea of being bold with new tools as well.
Yes, we are as well. Judge Wood, the point has been made a few times throughout this hearing that antitrust supposedly protects competition and not competitors. You wisely noted in your remarks that we can't have competition without competitors, and our antitrust laws also prohibit unfair methods of competition. Isn't this statute broader than antitrust laws? Should Congress clarify that it's a far-reaching tool given this repeated confusion even here in the hearing room today?
Well, thank you very much. I think at this point, clarification might be welcomed not only, frankly, by enforcers, as the chairwoman was saying, but the business community is very happy to deal with clear rules that everyone understands, that their general counsels or their little small lawyer or whoever it is can just say to them, if you do this, you're going to be okay. If you do this other thing, you're inviting attention from antitrust enforcers or private plaintiffs. And so I actually think clarification from Congress about thresholds, about what to do with the nascent companies, the very little companies that have a lot of promise that really fall through the cracks these days because it doesn't increase concentration very much in the moment. It's just the longer term. But I think that there would be a great benefit from clarity, even if there was a little bit of risk of getting it wrong sometime.
Let me quickly ask you about the question of concentration, because you mentioned that antitrust laws have always been concerned not only with consumer welfare, but also with concentrated economic power. Can you quickly elaborate on what you mean by concentrated economic power and how you think this subcommittee should understand it?
Learned Hand said that concentrated power certainly existed at about the 75 to 80% level of the relevant market. The Europeans would tell you it's more like 40%, but I think when you control, let's say, more than half of a market, you can behave independently and you don't have to care what consumers think. That's the problem.
Thank you so much. I really believe we need to reassert the broader vision of a democratic economy and society that once guided antitrust enforcement. And I'm looking to do that, reinstating these clear rules of the road that apply equally to powerful corporations. Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. I now recognize the distinguished ranking member of the committee, Mr. Buck from the great state of Colorado, for 5 minutes.
Thank you. Thank you, Mr. Chairman. Commissioner Phillips, I want to ask you a question with a quick answer and then go to the chairwoman, acting chairwoman also for the same question. When was the last time the Federal Trade Commission brought a case on innovation only? Not price and innovation, but innovation only.
Off the top of my head, I can't think of that.
Chairwoman,
but I would have to check the record.
Acting Chairwoman Slaughter.
Well, I think innovation was very much at the heart of the complaint we filed against Facebook, right? That was not a price complaint. That was about innovation and access and nascent competitors. So that's one I would point to, but I agree with my colleague that I'd like to give a little thought to more.
Oh, okay. And Commissioner Phillips, did you support the FTC recent action against Facebook?
I did not.
Acting Chairwoman Slaughter, did you?
I did. It was voted out on a 3-2 vote.
Okay. What change, Acting Chairwoman Slaughter, what changes, if any, well, let me ask you this way. Should Congress consider codifying the guideline that was issued jointly between the Antitrust Division and the Federal Trade Commission on vertical mergers?
No, Congressman, honestly, I was concerned that the guideline as it was issued was overly crediting of claimed pro-competitive benefits of vertical mergers and counted a number of harms that I think are important. So I would prefer not to see those guidelines codified, and in fact, I think we should consider withdrawing them.
Okay, okay. How about shifting merger presumptions? What is your position on that?
I think changing presumptions in mergers, particularly in the kinds of cases where there is clear evidence of anti-competitive harm or clear evidence of dominance, would be very helpful for enforcers.
And Commissioner Phillips?
I think it's the answer I gave to Mr. Stubbe earlier. I think we are conducting a study right now, in particular in the big tech context of acquisitions. And when we create bright line rules in antitrust, we do our best when we target things for illegality that are mostly bad.
And Commissioner Phillips, what should we do about the recent court interpretations of Rule 13B, which some have suggested undermine the effectiveness of Rule 13B?
I do think Congress needs to give us clarity on 13B. I don't know what the Supreme Court will do, but we've certainly had a lot of roadblocks from courts. We go into these negotiations and people throw 13B decisions in our face. So I think clarity from Congress on that would be welcome.
What is clarity? A lot of us have trouble seeing sometimes. So what is clarity?
So there are two issues. One issue is our ability to get money as opposed to just an injunction barring a company from doing something under the statute. I think speaking to that is thing number one. The other, there are a series of decisions, and this comes up in the Facebook case, has to do with how far back we can go once the conduct has stopped. And so I think that getting clarity from Congress when they want to allow us to use 13B to get money, how late after the conduct stops, I think would be terrific.
Acting Chairwoman Slaughter, your thoughts on clarity for 13B?
I think it would be critical for Congress to speak not just with clarity, but to restore the understanding that courts have had for decades of the power that 13B gives the FTC. Judge Wood wrote an incredibly eloquent and I thought very persuasive dissent in the CBC case in the Seventh Circuit that tackled some of these issues. If we cannot get monetary redress, we can't make consumers whole when we have seen anti-competitive conduct or fraudulent behavior or any of the law violations that the FTC tackles. And if we don't have the ability to go into court and stop bad behavior from recurring, if we don't have the ability to get an injunction, then there is very little that we can do to prevent a company, once it has stopped doing its wrongdoing, even if it has stopped that in the shadow of an investigation, from restarting that behavior. It renders the agency very limited in its ability to go to federal court. And I think that's a real problem for consumers, not just in consumer protection, but also in the antitrust realm.
And I would be remiss if I didn't mention that I appreciate my fellow Coloradan joining me in supporting the Colorado Rockies. So thank you very much, Mr. Attorney General.
I'm going to leave out the modification he said about his support of the Rockies, I now recognize the very distinguished gentlelady from the state of Florida, Ms. Demings, for 5 minutes.
Thank you so much, Mr. Chairman, and thank you to our ranking member as well. Thank you to all of our witnesses for joining us today. I think that we all agree, I believe, that There's a need to modernize our antitrust laws to create a market that gives everyone a fair shot. That's what we're talking about, a fair shot to healthy competition and holds bad actors accountable. Judge Wood, in your written testimony, you explained that courts today assess allegations of exclusionary practices under the rule of reason. As a result, courts are left to try to distinguish between what is an anti-competitive exclusionary practice and what is merely tough-nosed competition. Your testimony makes it clear that while making these distinctions isn't impossible, it can be challenging. What about this is challenging and why?
Well, thank you very much, Congresswoman. It's challenging, first of all, because it is done under the rule of reason, which, I mean, such a mushy term actually comes all the way from a 1911 Supreme Court decision. And so you need to figure out a lot of things with the help of very expensive economists, market studies, who has market power, what's the impact of this practice in the market, why was it undertaken? It's a very elaborate inquiry. So it deters plaintiffs from bringing those lawsuits to begin with. Not everybody has a pocket deep enough to support that. The enforcement agencies of the federal government or the state attorneys general also live on budgets. They have to assess very well what they're doing. So it's a big investment. Now, you could have rules of thumb. You could say that if somebody's engaged in exclusionary practices of some type and they have, I'll pick a number randomly and say 40% of the market, then maybe we have a presumption there, which would leave a safe harbor for a tremendous number of small and medium-sized businesses to engage in whatever practices they thought were most efficient for them. I think that's what we want to do. We want to let them have some room to compete, but we also want to make sure that the big guys don't turn into Facebook, buy or bury.
Thank you so much, Judge Wood. You also talked about legislative changes in the remedy areas. You talked about injunctions, damages, but you also talked about even additional remedies. Could you just elaborate a bit on those, please?
Yes, certainly, I'd be glad to. I will preface it by saying that when I was at the Department of Justice, which granted was a long time ago at this point, my job, like General Weiser's job, included the international portfolio. So I learned a lot about other countries' competition laws. Most of them have among the remedies they can use the possibility of a civil fine. And even though that's not ideal, I would freely say that some fines are going to be too small and they may be a slap in the wrist, and it's not something you'd always want to use. But if you're looking at the choice between forbidding somebody from doing something, that might be a bad fit for a particular case, or ordering somebody to do something, license your patents or have open architecture on something, whatever. You might feel that that was intrusive as well. Divestiture is great when that's the kind of structure of the market, but that's not always going to be right too. So I was thinking that you just do what everybody else in the world that I know of has done and add civil fines to the menu.
Thank you so much. Attorney General Weiser, what do you see as the primary reasons from your perspective, that enforcement efforts have been weakened, and what do you believe that Congress can do to help?
Thank you, Congresswoman. There has been, and I, with great respect for Judge Wood, it is called the Chicago School, but not to take away from her often called post-Chicago School views. The Chicago School thinking has had such an influence that has influenced both courts and enforcers to be afraid of bringing cases that would constitute so-called over-enforcement. And as Judge Wood said really well, using Kodak as an example, we can see companies have durable, sustained market power that harms consumers, and we will sometimes see people talking themselves out of bringing cases. What we saw with Google, for example, was an ability to move from dominating search in the desktop to dominating search in mobile. As the case that General Peterson and I are leading right now, we want to stop Google from dominating the Internet of Things or connected cars or other sorts of devices. And so what we need to do is get enforcers committed to bring cases. We've got to have laws and a message to the courts that it is important to have robust enforcement and not to create these artificial rules. The American Express decision is a notable one that makes it unduly difficult for enforcers to get the sorts of relief that will protect consumers.
Thank you so much, Mr. Chairman. I yield back.
The gentlelady yields back, and I recognize the gentlelady from Pennsylvania, Ms. Scanlon, for 5 minutes.
Thank you, Chairman Cicilline. At a hearing last July, I raised concerns about Amazon's scheme to artificially lower the prices of Amazon brand diapers in order to drive down a competitor's profits and then eventually acquire that company. The tactic had real effects on parents who saw the cost of Amazon diaper products rise once the competition was eliminated. Attorney General Weiser, you testified today that that's the type of conduct that we should consider in violation of antitrust laws. And in your remarks at the George Mason Law Review's 24th Annual Antitrust Symposium this past February, you talk about the very high bar set by the courts for punishing predatory pricing schemes like the Amazon diaper scheme. Can you talk about why the bar is so high and what this means for smaller firms, and then what legislative recommendations you would make?
Thank you very much, Congresswoman, and appreciate you reading that article. The case that is at issue, it's a case influenced by the Chicago School of Thinking, is known as Brook Group. And famously, there's a statement in that case that predatory pricing schemes are rarely tried and even more rarely successful. That statement came out of works by Chicago School scholars like Judge Bork. It didn't have a basis in reality. Unfortunately, that statement has influenced courts, including the case I talked about in my testimony, the American Airlines case, where what happened was exactly what Judge Wood talked about. There was the flights between Dallas and Wichita, and after rivals, low-cost carriers came in, American just flooded the market, moved to a whole bunch of flights a day, lowered prices, and then that pushed out the rivals from the market. And as the concern you mentioned, once the rivals were gone, they raised their prices to back where it was. And the courts took a very narrow view of cost. And the courts have also taken, at times, a very demanding view of a recoupment requirement. And that has really led to an absence of these cases and has created, as our chairwoman Slaughter noted, a lack of the sort of deterrence we'd like to see. So the short version is I do think we need to either have a narrowing of this precedent in the courts, and I've written an article on this with a colleague of mine at how that could happen, and or Congress can overrule this Brook Group decision by statute. I do believe you have to have below cost pricing and then define that appropriately. And then also you have to recognize, and this is again what Judge Wood, another co-author of mine, said, is the reputation for predation that gets developed by an American Airlines, that lasts. We haven't seen entry into the airline industry much at all over the last 20 years after this case was decided. That's a problem for airline consumers.
Thank you. That's very helpful. I also would like to touch briefly on the connection between antitrust law and user privacy regulation. Mr. Walker, in your testimony, you talk about the need to consider privacy regulation and competition policy jointly, pointing out that dominant firms have used European privacy protections as a competitive weapon. And I also saw in your testimony that you talk about the fact that these dominant social media firms are unlikely to self-correct. Can you tell us can you explain that observation further?
Certainly. So, I mean, the observation about privacy is just that we have seen some of the platforms are taking advantage of rules around the restrictions on sharing data outside of their ecosystem, but being allowed to share data within their ecosystem as a way of butting their competitive position. And in the UK, we currently have a case against Google where Google has said they're going to phase out third-party cookies, claiming, saying, I mean, reasonably, that they're doing that on privacy grounds, but that is going to have real competition effects, which is why we have instigated a case against them. But why do I say that it doesn't look like they're going to self-correct. Well, I mean, if you talk to Google, even up until 2 or 3 years ago, they were telling us, no, competition's only a click away, and we could be wiped out. Just look what happened to Yahoo. Facebook will say the same about MySpace. And you sort of think that 15 years ago, yeah, okay, maybe you had an argument. But if those are your examples of how your position can be taken away, if you're having to go back that far, then I don't think they're very convincing arguments. And the natural network effects of these incumbents and their entrenched position through their ecosystems makes it very hard for people to enter and compete.
The time of the gentlelady.
And Mr.
Oh, thank you. I think the gentlelady was about to yield back. Thank you. I now recognize the gentlelady from Georgia for 5 minutes, Ms. McBath.
Thank you so much, Chairman. I really appreciate it. And thank you to each and every one of you that is here before us today. It's really important that we hear from you. Chairwoman Slaughter, your testimony mentions a few ways Congress can strengthen the FTC's enforcement capabilities. And I also want to make sure that the FTC has strong investigative authority to root out problems that harm competition or reduce consumer choice. I'm concerned that this investigative authority does not apply equally to all industries. With the cost of healthcare burdening so many Americans, I think the FTC must be able to study the insurance industry as it deems appropriate. And there's particular cause for concern in light of what this committee learned from our past hearings on consolidation in healthcare. At that hearing, Dr. Marty Gaynor told us that the two largest health insurers have 70% of the market and over 1/2 of all local insurance markets. So, Chairwoman Slaughter, do you think that the FTC should be empowered to study the health insurance industry without getting specific permission from Congress?
I do, Congresswoman. That would be very welcome.
Well, thank you so much. I appreciate that. So, and Mr. Walker, or excuse me, should I say, Dr. Walker, as an economist, why do you believe that competition, not monopoly, drives innovation and improves consumer choice?
I mean, there's been a debate in economics over this issue, and there's a Schumpeterian view that it's monopoly, that monopolists have the money to invest and to drive innovation. There's the Ken Arrow view that no, it's competition, that the incentive to escape from competition, to give yourself a competitive advantage, is what drives innovation. Just empirically, I think the evidence is that competition is what drives innovation. Competitive markets lead to more innovation than markets that are monopolized. Monopolists tend to get a bit lazy. If they don't face competitive pressures, they don't have an incentive to innovate. Competitive firms don't have that luxury. They need to innovate, otherwise somebody else will, and they'll be dead.
Thank you. And Judge Wood, your testimony notes that antitrust law has long been concerned with promoting innovation and that concentrated economic power can stifle innovation if it's left unchecked. A recent article in The Verge highlighted an example of a small business that created a popular crossbody camera bag and sold it on Amazon. And Amazon then came out with its own Amazon Basics bag. That's what they called it. And it bared a really striking resemblance to the bag that the small business developed. It even had the same name, and just until recently. There are many allegations of Amazon using its monopoly power over sellers and the data it extracts from them to copy successful products that are sold on its marketplace. These include shoes, a car company that invests, I think it was a car trunk organizer, and seat cushions, but all for a lower price than the company that invested in the product's research and development. And as we stated in our report, the subcommittee's report, the subcommittee, we heard repeated concerns that Amazon leverages its access to third-party sellers' data to identify and replicate those popular and profitable products from among the hundreds of millions of listings on its marketplace. So, Judge Wood, should we be concerned that entrepreneurs will no longer have an incentive to innovate if dominant firms leverage their monopoly power to copy and undercut small innovators?
Well, you've really put your finger on a very important question, in my opinion, which is whether our whole categories in antitrust have become too rigid. You know, we think of horizontal restraints, and Amazon's not competing with another Amazon. Amazon's actually the only player. Vertical restraints, where Amazon has various people who it makes its facilities available to. And I think there's a way that should be loosened up. There's a way in which we need to understand that these leveraging theories lead to consumer harm. Now, you might say theoretically the answer, I know about this bag case, that the answer is more strong trademark laws or more strong other laws. But frankly, small businesses don't always have the budget, to litigate forever on a trademark dispute either. So I think these leveraging theories are something that would repay careful study.
Well, thank you so much for your answers, and I believe that I must yield back the balance of my time.
I thank the gentlelady and now recognize the gentlelady from Pennsylvania, Ms. Dean, for 5 minutes.
Thank you so much, Mr. Chairman. And I apologize for having been in and out. I hope you will know that I was doing my best to listen in, but if I repeat a little bit, I hope you'll bear with me. Judge Wood, I wanted to ask you, noted in your written testimony, antitrust enforcement has been weakened for a variety of reasons. Can you describe the primary contributing factors and how do we appropriately reverse these trends?
Well, thank you very much. If I were to speculate, the primary reason is that the chance of success in any particular antitrust case, especially a case that's not a hardcore cartel, horizontal price fixing, division of markets, the things that are under the per se rule, it's become very hard and very expensive to win those cases. And so lawyers are going to actually face ethical responsibilities. Can you even file the thing under the rules that govern, stating a good faith claim? And as we get rule after rule, inspired by what General Weiser keeps calling the Chicago School, saying, well, even if we have evidence that all the companies in this business are coordinating their behavior, somehow that's not enough. We need a smoking gun where they all sit down in a room and say, let's charge the same price. It's that assessment of likelihood of success in the courts. Expense is another thing. As you get rid of clear rules, such as the per se rules, then you definitely raise the expense of litigation, and you have to assume people are rational. They're not going to just throw dollars away at something year after year if it's not likely to result in some sort of relief. So I would single those out.
Thank you very much, Your Honor. Dr. Walker, are there advantages to Europe's abuse of dominant standard compared to the United States law in its ability to reach anti-competitive conduct by monopolists or dominant firms?
Well, I mean, certainly the provisions properly used can be very effective at stopping firms abusing their market power. However, I mean, there are definite limits that you should be aware of. One, the cases take an awfully long time. So if we think about Google Android, which I think most economists would think was a pretty obvious case, the complaint was 2013, we got a decision 2018, and it's now on appeal. So they still take too long. And secondly, I would say they don't generally allow you to remove the source of the market power. And if you've got a sophisticated firm with substantial market power and you stop them being able to exercise that in one way, they're sophisticated firms. They're going to find another way to exercise that market power. And you end up playing a game of whack-a-mole. So, yes, it's a useful provision, and we certainly have got a number of cases that we are pursuing under that provision, but it's a long way from being perfect.
I appreciate that, and certainly we struggle here in our system with the length of court cases and appeals, et cetera, et cetera. Also for you, Dr. Walker, why do you believe effective merger control is an essential element of restoring competition in digital markets and addressing the dominant platform's significant and durable market power?
Well, I mean, you have to learn from mistakes you've made in the past. And We look at Facebook and we look at its position with Facebook and Instagram and WhatsApp, and you have to think that those acquisitions have not been good for consumers. So you want to be in a world in which those acquisitions in future are picked up. We have learned something, I think, about how to think about these acquisitions. And one of the things we've learned is that under a balance of probabilities standard, it's extremely difficult to be able to in 2012 and say, yes, Instagram is a bad merger. I can be more likely than not sure it's going to lead to consumer harm. The problem is, if it does lead to consumer harm, it leads to a lot, as we've seen. So that's why I think actually we need merger control with a lower standard of proof for these sorts of cases. So you can go in and say, this merger, there's a reasonable prospect it's going to be anti-competitive and a lot of harm if it is, therefore we should be able to block it.
I thank you for that and for the focus on consumer harm. I see my time has expired and I yield back.
The gentlelady yields back. I now recognize the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, for holding this very important hearing. We've spent nearly 2 years understanding the complex problems posed by big tech companies that have full control over their marketplaces. And now we finally turn to the big question, which is, how do we fix this? Since this investigation began, I've been dismayed to learn about the depth of the anti-competitive issues that exist when just one company holds the keys to an entire segment of the economy. Whether a company prioritizes its own products for users or prevents the platform availability of a competitor application, big tech frequently exhibits self-preferencing behaviors, stacking the deck to enable themselves to get bigger while squeezing the life out of the little guy. What we're dealing with here is what happens when big becomes too big. Companies are not people and they don't have a soul, they don't have a moral compass. Therefore, we can't allow corporations to do the right thing by way of competition and their competitors. That's why Congress enacted the antitrust laws more than a century ago to keep our economy competitive and to avoid the immense concentration of economic power that we see today. But as with other critical areas of the law, such as the Voting Rights Act, the Supreme Court has whittled away at the antitrust laws over the past several decades. And when coupled with forced arbitration clauses in consumer agreements, which block everyday people and small businesses from getting their day in court, it has become practically impossible to hold corporations accountable when they break the law. So I'm looking forward for us to come up with some great ways of curing this by way of legislation. General Weiser, I'm very concerned how anti-competitive conduct by dominant firms like self-preferencing is undermining innovation and preventing competitors from entering the market with better services and giving firms with gatekeeper power control over the entire marketplace. You've also testified that this dominance has created a kill zone, as you call it, for new companies, undermining investment in the generation of innovation. Is current law enough to address these trends? And how would legislative action help address these trends by removing obstacles to enforcement?
Thank you. I want to underscore that these hearings and this focus is a valuable complement and fits very closely with the agenda of pursuing cases like the Facebook case, like the Google case. We're confident we can prevail under current law in these cases. The Microsoft precedent I mentioned gives us a roadmap for how we win these cases. Part of what you can do, and Chairwoman Slaughter mentioned this, is make sure to encourage and invest in antitrust enforcement as a critical part of the economy. I just want to pick up a point of innovation that you have adverted to and that Judge Wood mentioned during AT&T's realm. AT&T had this gatekeeping monopoly where MCI and Sprint couldn't enter effectively into the long distance market without interconnection that was non-discriminatory to AT&T. When there was an effort to build a fiber optic network, there was no takers to buy the invention at that point. AT&T told the folks at Corning, when we want to build a fiber optic network, it'll be after we depreciate our current network and we'll build it ourselves. After the AT&T divestiture, a pro-competitive antitrust decision, both Sprint and MCI purchased fiber optic networks. And some of us are old enough to remember the pin drop commercial that Sprint had, and AT&T was forced to compete in the marketplace. That's what helps consumers. Choices in products, rival firms that innovate. I agree with Dr. Walker. Innovation comes from competition, and allowing firms like a Google or a Facebook to squelch out competition to deprive consumers of choice, that's bad for consumers, and we need to fight for competition.
Thank you, General. Dr. Walker, you are a leading antitrust economist, and in your statement, you write, quote, "The right answer to uncertainty and complexity is not inaction," end quote. What do you believe is the biggest danger in taking a neutral approach to big tech monopolies?
Well, the biggest danger is that antitrust authorities look at these cases and we say it's all too difficult, so we'll do nothing, and we'll get exactly the wrong answer rather than trying to get roughly the right answer. And I mean, I think historically, competition authorities around the world have tended to go for inaction in the face of uncertainty, and that's been a huge mistake.
Yeah, what are the global consequences that?
The time of the gentleman is
Okay,
back, but you,
out
of
of
course,
town.
finish your thoughts.
Okay, yeah, I was just wanting to know what would be the global consequences if the U.S. fails to act, sir.
Well, if we fail to act, then I don't see why the firms would stop their behaviour. And we know that their behaviour is exclusionary. They do squash nascent competitors. They do use leverage strategies. So the situation will get worse unless we competition authorities around the world act.
Thank you, and I thank the chair, and I yield back.
The gentleman yields back, and I'm just going to ask the witnesses to indulge me just for a couple of minutes, and I will, of course, give the ranking member the same opportunity just to wrap up with a couple of questions. Commissioner Phillips, I'd like to turn to you. You testified that antitrust is a fact-intensive inquiry and that competition cannot solve every problem, but no one is seriously debating that. We're here to discuss reforms that will boost competition precisely because of the evidence, because of a century of experience that's taught us that competition in the economy is always desirable. But helpful to us is understanding how enforcers think about these issues. And so your presence here is useful. You, for example, voted against the FTC's bipartisan complaint against Facebook for monopolization, correct?
I did.
And you're aware that 48 state attorneys general, Republicans and Democrats, agreed that this evidence warranted filing an antitrust complaint, correct?
I am.
And you've read the underlying evidence in those complaints, I assume?
Yes.
So you're aware that Mark Zuckerberg told Facebook's chief financial officer that the purpose of acquiring Instagram was to neutralize a competitive threat and buy the company time, correct?
Yes.
And you're aware that the company's own market data shows that Facebook has tipped the market in its favor in terms of monthly active persons, attention, and time spent on its platform, correct?
I think that's right, but I'll accept the premise for purpose of the question.
Right. And you also know that Facebook's own data scientists and economists believe that Twitter and Snap are not meaningful sources of competition to Facebook, correct?
I'm not aware of that evidence, but I have no reason to disagree again.
So I guess my question then is, in the light of all that, tell us, as we think about these issues, what additional evidence would you have needed, or is your opposition based on something else that we don't understand?
So my quibble with this case begins, Congressman, with the fact that these are transactions. The gravamen of the case is two transactions. It's Instagram and it's WhatsApp. And these are transactions that were brought to the attention of the Federal Trade Commission before I was there, the better part of a decade ago. There is no allegation in the complaints of fraud in that process or anything like that. The agency did what it did, and for years, the company was allowed to make decisions, made investments. So a big part of this goes to the integrity of the process. And for the government to come back in years later, I don't think the government is barred as a matter of law later from bringing a case.
In fact, it's specifically authorized as a matter of law, isn't it?
Sorry?
It's specifically authorized to do that as a matter?
Yes, we can go in after the fact. But as a general matter in terms of mergers, the longer you wait, the more investments the company make. And I think that presents a real issue. I can't undo the fact that the agencies did what it did. I also think on the merits, there are some questions to do with market definition and effects under Section 2, but I do think this broader framing is really important. I wasn't there when this happened, but it did happen.
Yeah. And finally, Mr. Phillips, Commissioner Phillips, you testified repeatedly today that the antitrust laws are working just fine. But that's simply not true. To give one example, the FTC recently suffered a crushing defeat in its effort to challenge an anti-competitive hospital merger just a few months ago in the Jefferson-Einstein case, a case you voted to bring. In fact, the agencies lost a number of the cases you cited as examples of aggressive enforcement under current law, such as the DOJ's Sabre-Fairlogics case. So you argue that the law is working just fine, but don't the outcomes in these cases say just the opposite?
So, Congressman, I don't think I used the phrase just fine. And I would agree with you that courts sometimes get these things wrong. I voted for the Jefferson complaint. I think we were right. I think the court was wrong. I agree with you. I also agree with you that the court's interpretation of Amex in the Sabre-Fairlogics case was also wrong. But that doesn't mean to me that the entire enterprise is broken. And so the examples I gave before, in terms of small competitors being bought by incumbent firms, this is Illumina PacBio, this is Harry's and Schick, this is Procter & Gamble and Billy. On the DOJ side, it is the Sabre-Fairlogics case what they brought. They brought the Visa Plaid case. In all of those other instances, the mergers were called off. And these negotiations take part in the shadow of the law. So I guess I'm a little bit optimistic because of my experience about the ability of agencies to stop some of these mergers.
Well, I thank you again for your testimony, and I'm happy to yield to Mr. Buck for any wrap-up questions he may have.
I'm going to ask one very quick question because we both have to go vote very quickly. But Commissioner Phillips, based on Chairman Cicilline's questions, don't your answers and the concerns that the chairman has indicate that we need more aggressive action and not less aggressive action from Congress, from the agencies, and from the courts?
So I do think, as I said before, the agencies are pivoting to focus on some of these issues. I think you see it in the enforcement program. I think that's a good focus. You've heard a lot about error costs, and one of the things that I am saying is that when I am looking at a merger ex ante, before it happens, I'm going to be willing to take some more risk. And I think that's an important cultural change that has happened at the enforcement agencies.
Thank you very much for your time, and I very much appreciate the witnesses' time today.
I seek unanimous consent to add a number of letters and statements regarding the committee's work to strengthen the laws to address monopoly power into the record. Without objection. In closing, again, I want to thank, on my behalf and behalf of Mr. Buck and the whole committee, our extraordinary witnesses for their testimony at today's hearing. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record, and the hearing is hereby adjourned.